It is my earlier granted interim bail for a period of 3 months.
Yeah.
Earlier granted interim bail, the appellant manner, for 3 months and timely surrender. Therefore, in the year 2024,
What do you want now?
I filed a
Another
IFR
bill.
notice.
Pardon to mention WPC 7823
Yeah.
WPC 7823 of 2017. Order of a tribunal has been challenged. Matter has been fixed to we commencing 14/7, but that has not been listed. So I have filed 2 memos before this unfold, but it has not been. Next week, any time.
Okay.
The appellant is in custody more than 10 months.
This matter I have mentioned last week that content matter is going on in the tribunal that is fixed to 411 for non-compliance of the order personal appearance. While hearing the matter, though matter is fixed to 24, but inevitably order shows 1711. That is the reason matter could not be listed. I have filed memo last week. Your lordship, I also filed IF to modify that. So your lordship on 29th, your lordship, otherwise you will be highly judicial. 29th, your lordship.
Terminal benefit of senior citizens.
Yes, Mr. Das.
Item 3, I feel permitted to withdraw with liberty. Item 3.
We are appearing for you are appearing. Any interim order was passed?
No.
Mr. Das? Mr. Das, Land Counsel for the petition files a memo for withdrawal of the writ petition, which is taken on record. Mr. Ramchandra Panigre, Land Counsel for the opposite party is present. The writ petition is disposed of as withdrawn.
Your lordship say disposed of.
Disposed of as withdrawn, yes.
Lordship, item number 28. Lordship, I am playing for an adjournment. I have already informed the counsel for the opposite parties.
28.
Your Lordship.
You are for the petitioner.
Your Lordship, I am for the petition.
Pleading seems to be complete.
Your Lordships, on last occasion had directed us to file all the original applications, count and rejoinders.
Have you informed Mr. Sasibhusan?
Your Lordships, I have informed you.
What is your full name?
Your Lordship, Shamsundar Tripathi.
You have no power in yes,
Your Lordship, sir.
Mr. S.S. Tripathi, Land Counsel for the petitioner, submits 6 for an adjournment, and he further submits that he has taken the consent of Mr. Sasibhusan Jena, Land Counsel for the opposite party. When you want,
Your Lordship, 21st of November.
so any interim order is there?
No, Your Lordship, no interim.
21st of November.
Your Lordship, because my senior has to
Take
ask
this matter on 21st of November 2025.
Very grateful to Your Lordship.
Item 12. 12, in this matter, I am for the opposite party bank. My lord has directed me to file the counter. The counter is required in this matter. I have got the instruction. I need someone. I have already expressed.
When you will,
My lord, next week.
next week,
Right.
you give the copy of the counter affidavit to the
I will supply earlier.
Mr. Farol and counsel appearing for the Bank of India submits that he intends to file counter affidavit during course of this week, and the matter may be taken up next week. Mr. Rothol and counsel for the petitioner is present and he has no objection to put up this matter. Let it come on 7th of November. Yes. 7th is a Friday. Any difficulty or next week?
The matter has been fixed for on that day. 10th or
10th.
10th.
Is this matter,
Obliged.
10th of November 2025. Copy of the counter affidavit we served on the land council for the petition.
We have not issued notice.
Huh?
We have not issued notice. This matter.
My lord, item 22.
Just a minute. Counter the objection for that. Yes,
Item 22. I am for the petitioner, my lord.
22.
22, my lords.
22 years.
I will pray for taken up next week on the heading of orders, my lords, because during the challenging the order passed by,
You are for,
I am for the petitioner, Union of India, my lord.
okay. Who is for the other side?
Mr. NP sir, sir.
Are you? Yes.
ସେଟା ଗୋଟେ କଣ୍ଟେମ୍ପ ପିଟିସନ ଫାଇଲ କରି କ୍ୟାଟ ସେଟା ମୁଭ କରୁଛନ୍ତି ଆଜ୍ଞା ଏଠି ପ୍ଲିଡିଂସ୍ କମ୍ପ୍ଲିଟ ଫାଇନାଲ ଡିସ୍ପୋଜାଲ ପାଇଁ ଅଛି ତେଣୁ ଆଇ ଏମ୍ ଫାଇଲିଂ ଏ ଆଇ 18617 minus flag C. ତେଣୁ I therefore requested taken up the orders, my lords.
You want it to be taken up for orders next week?
My lords.
Mr. Sahoo, learned counsel for the opposite party is present. Mr. Rai, senior panel.
Senior panel counsel.
Appearing for the Union of India service. That the matter will be taken up orders for consideration of the interim application.
My lords. 186.
Matter on 7th of November 2025 it will come. Yes. For orders purpose.
Weekly list, item number 1.
Item number, I'm apologetic, your lordship. In fact, my lord has been pleased to direct on the last occasion to verify whether there is a necessity of an amendment or not. Well, only
Yes.
till lords. In fact, in the meantime, the council was appearing for this petition. He has been already joined in the tribunal. So
Last
that's
time,
why,
we allowed the
My lord,
amendment
my lord.
application in 2024.
my lord, 2011 to 2024 also, your lordship has been pleased to direct.
What do you want?
Only 3 days time so that I can verify. Lordship may
For the
keep it 5 days.
consolidated repetition.
I'll file that also.
You have already filed.
I'll file that.
You will file.
My lord. 2 days time.
You are for the Union of India.
My lord. It was filed by my lord senior Mr. Mishra Das.
You are Mr.
SS customers.
Kashyap. Your name is there.
Your lordship. Because I've sought for time.
SS Kashyap and Central Government Council or
Senior panel council.
Senior Panel Council appearing for the Union of India submits that to the prayer for amendment. What is this? Of the petition has been allowed since 28/11/2024. But inadvertently, consolidated copy of the petition could not be filed. And the matter may be taken up next week. So that in the meantime, you will file the consolidated copy out of this matter. Such and such, then give a date. Yes, next.
Okay.
Item 2.
May it please your lordship. Lord, I challenge the order of 29 September 2021 passed under section 14 and the consequent action under section 13(4).
14 you can challenge there.
Yes, I'm coming there. I went there.
Yes.
Unfortunately, my lords, what the DRT held, that this is barred by limitation.
DRT and then DRAT.
Both said is barred by limitation.
Okay.
Lord, I was just told by my learned friends that there is an order of the Supreme Court where your lordships will recollect, my lords, for COVID, there was a direction that during that period,
That will be excluded.
the limitation period will not be counted. Your lordship may have the order. I read it from.
Show motor 1.
Yes.
14 took place during that particular
Yes,
period.
because your lordships will only have to see whether 29/21 is covered or not. So if your lordships kindly see the order, kindly come to paragraph 5.
Of this particular.
Yes.
Yes.
Paragraph 5. taking into consideration the arguments advanced by the learned councils and the impact of the surge of the virus on public health and adversities faced by litigants in the prevailing conditions, we deem it appropriate to dispose MA number 21 of, your lordships have that paragraph? Yes. With the following directions. The order dated 23rd of March 2020 is restored, and in continuation of subsequent orders dated so and so, so and so. Now this line is important. Right? It is directed that the period from 15th of March 2020 till 28th of February 2020 shall be excluded for the purposes of limitation. So therefore, minutes, an order passed under 29/2021 is squarely covered by this order of the
When
Honorable.
that 14 application order was passed?
The order, yes, I'll show that to your lordships in a minute. Kindly see, where is my pen?
14 order was passed by
By the collector.
collector. When? When?
I'll tell you, lordship. It is on 20th of September 2021.
20th of September.
Yes. And your lordships will get it, my lords. At page 61, annexure 5.
61. 20th of September, 19.
Again.
All the date of 20th of annexure section 14 order का page
पूरी बार ना पूरी बार.
पूरी बार 2019
Oh.
पूरी बार
Just one second. I'm sorry, my lord. Your lordship may see page 63. 62.
This is the order of.
I'm so sorry, my lords. My apologies.
This is 20th.
September.
20th of September.
Again, 21. So therefore, my lords, my first
The period is, I think, 45 days. Huh?
the period is 45 days. Your lordship is right.
To file that 17 application.
I filed that 17 application. My lord, I have other arguments also.
Yes.
But on the face of this order, my lords,
So when you challenge this order before.
we have challenged this order on 7/12/2021.
7/12/2021.
Again, my submission to your lordship is, my lords, all orders passed between 15th of March 2020 till 28th of February 22 shall be excluded for the purposes of limitation as may be prescribed under the general or special laws in respect of all judicial, quasi-judicial proceedings.
But is that order passed by the DRT
But
which you stated to?
Let me tell you, lordship,
You should have brought this to the notice of, you have not brought to the notice. That is the reason the
Oh,
order
this
is
has
passed.
not been brought to the notice?
no.
That is the reason the order is passed.
I'm grateful.
You have gone in that RTI information and delay.
No,
to try to explain.
I'll tell you, lordship, there's another argument to that. There's another argument.
But the fact remains that this period.
It was not produced. No, I don't join issues there.
That fact remains.
Kindly see, my lord, page 43 is the order of the DRT.
Yeah.
And my lord, the operative part, if your lordships are kindly pleased to see, my lords.
DRT order passed when?
Yes. So in the DRT order at page 43, if your lordship sees.
15/11/20.
Yes, there is a order this is an order passed in IA 524 of 2021.
But is that IA?
That IA was for condonation. And it was stated that it is being filed as a matter of abundant caution. And what the DRT comes to hold, if my lords are kindly pleased to come to page 47 first. The DRT holds at paragraph 6. No, you'll actually see page 49. Kindly see the last two lines. Your lordships have it?
Yes.
The legislature has consciously not vested any authority on this tribunal to condone the delay in filing the essay / extended period as prescribed under section 47 of the Surface Act, no application for condonation of delay in any manner or for any reason whatsoever is entertainable in law. And my lords, it goes on to finally decide at page 53 . Yes, my lords. 53 is the final finding. my lords.
Wait, please. 49,
I got 53. 53 is where it ends.
Condonation or delay application is dismissed,
Again.
so therefore the essay.
And consequently, the essay is dismissed. So this is my first submission.
Let us see if you consider we demand it. Because
What
see,
do you
this order you can't escape from this order. This order has to be taken care of.
This is, I appear on caveat, I am for the option.
Yes, my lord, I am appearing with the bank.
Is for the bank.
So your lordship will see section 17(1). There is no such provision of filing section 5 limitation.
That's
But
right,
for
but
the-
see, this is a special circumstances. The Supreme Court said even limitation, statutory limitation under 138. I was party to this. I'm
Let us
hearing.
say he has by mistake,
Miller.
let us say by mistake, he has filed that delay condonation application.
Miller.
And let us also accept that the DRT has no power to condone the
Condone,
delay.
yeah.
That is your submission.
Miller.
But all the same, in view of this period, in all the cases that has been ordered to be condoned.
Hmm.
So how can you get over it? That is his submission.
In Miller.
Everything
there
came
is
to
two-
standstill during
Miller-
the
Miller-
pandemic time.
Miller, there
No,
is
no.
two order. One is prior to the COVID.
Yes.
Another is after the COVID. Now, if your lordship is two property simultaneously been sold, one is in December 19, another is what they are saying 21.
Hmm.
So both the order, and if they challenge one of the order, your lordship had said, I fully agree that if you will take that from March to 2020 to August, then there is a question of limitation may come. But if your lordship go to the previous, where the order has already been passed in December, my lord, that is not coming because it is joint property has been sold. In the meantime, the already sale certificate issued and the party has paid the payment and everything, and they have recorded also. If your lordship see that in new judgment,
he
that
has-
even if it is prior to the amendment, if he has not tendered the entire amount before the auction is held,
we have
then the
not
question is,
yet- Please,
Miller,
we have not yet issued notice in the matter.
Miller.
Is party, so once what my brother says that if we all agree, we can remand this
Demand
matter.
and
to-
argue everything there.
Argue everything.
Miller, only question is
May I
that
just-
part, what the.
Because on merit, he has not considered anything on the
The merit
question of
will not-
limitation that has been
Right.
dismissed.
Merit cannot be considered in the
You
time.
can,
of
yeah,
fees.
everything is open. You can argue that those
Let's,
things.
I am for the auction purchaser.
Yeah.
May I just make my
Yeah.
submissions? Let's kindly take page 61, Let's
Yeah.
kindly see the impugned order.
Hmm.
It is not quite correct. The 2021 order was under challenge. It is this order that was under challenge, which is 2012-2019, which
Yes.
doesn't fall in the eclipse period.
Puno?
This order was under challenge. This is section page 61.
That 14 order.
Yes, it's a
14 order is
section.
2019, you say?
Yes,
Yes.
and it
Doesn't
is
come
not,
under the eclipse of.
it doesn't fall under the eclipse of
That's
COVID.
what you are saying.
And that is number one. Number two, Millards, look at this ingenious thing that they developed. They say 2012-19 order came. I was not aware and I filed RTI on 24/11/21. I got that copy of the order on 26/11/21 and I filed the appeal. Millards, if they were not they were not aware of the order, all the while they were giving OTS proposals and everything.
That's
The
again on merit.
DRT.
That's again on merit.
No,
So
these are
yes,
all
it's on
merit. I
merit.
don't
It's
know.
on merit.
This-
However, Millards, the important fact is it is not covered under the eclipse period. The impugned order is not passed in 2021 only. It is passed in 2019, which they challenge, which is a section 14 order. Millards, I just read that page 61. Whereas the authorized officer SBI has filed a petition under section 14 of Surface Act to take possession and control of the secured assets / properties noted in the schedule below and hand over the same to him due to such and such.
The which Mr.
Yes, yes,
Raja was pointing out,
My
is
lord.
also under section 14.
correct.
Correct.
Milord,
There are two properties, na?
Yes, but they
Here,
have
that's
challenged.
what Bank council is saying. One
Yeah.
property I can understand, the other property is.
61, let nothing happen pursuant to 61. I am not on the earlier order.
My lords, my humble submission.
You are the auction purchaser of both the properties.
Yes.
Yes.
And rights have devolved onto me, Millets. Now at this stage, on a belated stage, they filed this appeal very conveniently by going in an RTI. Millets will kindly see what the impugned order says. Before your lordships, there's an impugned order is the DRT order, DR80 order.
80 odds.
Millets will kindly take the DR80 order.
Starts at 34.
Yes.
34.
Now, Millets will kindly just note. I'll file Millets a detailed reply Millets to this. I'll file a detailed reply Millets because and they have not placed the securitization appeal, the SA 143 that they had filed before the DRT. That will make clear what they had challenged. They have not filed it. Very convenient.
How many essays were filed?
One
essay.
that essay number 143
Just now.
that they have not placed on record. That will show what they have challenged.
Challenging both the options.
Yes.
Prior to that also another essay dismissed. 113.4 was issued in 2014.
No, that's a old one.
And
Essay number 143 of 2021. Here, that application has not been filed.
Not annexed.
Not annexed. All right, you take. We are just issuing notice to you.
We'll file a reply.
Lord, I would only ask that in the meantime, his client should not create third-party rights.
Okay.
Malat, I'll just indicate, Millets, one thing. Malat will kindly take 17 to 25 order of your lordships. 17 to 25 order your lordship will take. This order of DRAT Millet passed in November 2024. 17 to 25, the matter comes up for the first time before your lordships, where a copy of the petition was served on the caveator. On the next date, that is 10th March, none appears for the petitioner. Then, Millets, on the next date, before your lordship, it comes up on 19/9. Again, Millets, an adjournment is taken. Millets, I'll file my reply.
Today
What is the urgency of it?
Yes, day itself will fix the date.
Yes.
And that would be in November. You
I'll file my reply.
Final dispositive. Yes.
Millets.
This
And your lordship,
Millets, I'm on caveat, Millets.
you will not create any further third.
Millets, let there be no interim order. Millets. This is after.
Why-
Since 2021, we are in 4 years later.
Mishra, you have been misleading the court. I have been quietly listening.
The petition has been filed by the petitioners challenging the order dated 11/11/2024 passed by the Land Debt Recovery Appellate Tribunal, Kolkata, passed in the next appeal number 28 of 2024. Also, the order dated 15/11/2023 passed in IA number 524 of 2021, bracketly arising out of essay number 143 of 2021, passed by the Land Debt Recovery Tribunal, Cuttack, with a further directions to Land DRT Cuttack to hear essay number 143 of 2021 on merit. Mr. Forijal and senior advocate appearing for the petitioners argued that the petitioner challenged the order passed under section 14 of the Surface Act by the Land like that order, you are just showing that order.
52 minutes.
43 na
61.
62.
62. Okay.
I'm sorry, 61.
Passed by, no, you passed, that is 29 na.
I'm sorry, I'm so sorry. 62 is the order. 62.
Order dated, the order dated 29/2021. Passed by the collector and district magistrate, Sundargarh, under section 14 of the Surface Act. Before the Land and DRT. And along with such essay he filed an interim application for condonation of delay in filing the essay. However, the Lenin DRT, what is the order of the Lenin DRT?
Page 43, Manoj.
43.
DRT is page
43.
43. Yes.
The Lenin DRT by order dated 15/11/2023 has been pleased to hold that the legislature has consciously not vested any authority on this tribunal, to condone the delay in filing the essay and extend the period prescribed under section 17 of the Surface Act. And therefore, no application for condonation of delay in any manner and for any reason whatsoever is entertainable in the eyes of law. Accordingly, the Lenin DRT has been pleased to hold that since the petitioners failed to prove their case for condonation of delay in filing essay number 143 of 2021, IE number 524 of 2021 filed for condonation of delay, so dismissed being devoid of the merits, and also the essay number 143 of 2021. The petitioner challenged the order passed by the DRT before the Lenin ERAC Kolkata in Mishra number 28 of 2024, and the Lenin ERAC also held that the Lenin DRT rightly dismissed the IA number 524 of 2020 and essay number 143 of 2021 having treated as time barred. Mr. Porija, Lenin Senior Advocate, pointed out from the order dated 10th January 2022 passed by the Honorable Supreme in miscellaneous application number 21 of 2022. So and so. In so moto writ petition number 3 of 2020, wherein the operative part in paragraph number 5, it has been held as follows. Quote the entire 5.1. The Lenin Council for the petitioner argued that since in the case in hand, the order under section 14 of the Surface Act was passed by the so and so on 29/2021, and such period falls within the time stipulated by the Honorable Supreme Court, even though the petitioners erroneously filed under section an application for condonation of delay. Still then, the Lenin DRC should have condoned the delay, if any, in filing the essay, taking into account the aforesaid observation made by the Honorable Supreme Court in suo motu writ petition number 3 of 2020. I will stop. In this case, the bank, Mr. Mahapatra, Land Council has already entered appearance for opposite party number 1 and 2. and Mr. Sashwat Kumar Acharya, Land Council has entered appearance for opposite party number 5. So, the state has also entered appearance for opposite parties number 3 and 4. Is to notice on the question of admission indicating therein that the matter shall be disclosed at the stage of admission. Matter to be listed on 17th of November 2025. Counter affidavit, if any, be filed in the meantime by the Land Council for the opposite parties. Till next date, no third party interest shall be created by the opposite party number 5, who is the successful.
Let me file my reply, then your lordship can consider the entry.
You are in possession. I'm not disturbing your possession. I'm saying don't further create.
It's stated to be in possession of the property, shall not create in third party interest.
Lord, may I make one submission? Let the counters be filed by 10th. So that if any rejoinder we have to file, we'll file it.
This matter on 17th of November 2025, counter affidavit, if any, we file by 10th of November.
And I will file a rejoinder if any by the next 3 days.
Having a copy and the Land Council for the petitioner. And rejoinder, if any, we file by 13th of November 2025, serving a copy on the Land Council for the opposite parties. Yes, next.
Just a request. Could we have it on 26th rather?
Yeah.
26th rather. I have requested my learned senior is
26.
26th.
All right, then we are extending this matter on 26th and the counter to be filed by 17th and rejoinder by 20th.
Grateful.
Yeah.
The idea is not to further precipitate. Yes. That's the idea.
It's just a delay plus that's the issue.
Yes, next.
Grateful.
Item 4.
Please, madam. Petitioner the lady Loni, guarantor of case had taken loan from the bank. Husband of the petitioner is custodian in a criminal case. Now, my lord, the petitioner is given a represent to the bank, ICICI Bank, that she wants to pay entire dues of the bank by selling the house. And my lord, bank, my lord, this is the my lord letter.
No, you got that letter under Annex 5, which is dated 2/5/25.
My lord.
Page number 29.
My lord.
We'll come to that later. Because on this letter, you filed your representation dated 13/5/2025 under Annexure 6.
My lord.
Right?
Again.
So please come to Annexure 5.
Annexure 5, my lord, this is the order of collector and district magistrate, Ganjam, my lord. Where, my lord, this order was passed. Whereas I am satisfied from the application of the authorized officer, ICICI Bank Limited, landmark.
No, therefore, in exercise of the power conferred on me under section 14 of the SARFAESI Act, I do hereby accord permission to take possession of the secured asset.
My lord.
And the so and so property details has been given. The sub-collector comes SDM Barampur is hereby directed to deploy so and so.
My lord.
So the question is that if this is the section 14 application order, you are supposed to challenge before the DRT and not file a representation before the bank.
My lord.
Why have you not gone to the DRT?
My lord, because the urgent situation, my lord, I approach your lordship that in the development situation, my lord, husband of the petitioner is my lord custody. Wife is my lord staying along with the small child. So, my lord.
All these things you can tell the DRT also.
You will not.
My lord, only
period, you know that period is 45 days. That is also over.
My lord.
So instead of filing, you should have properly advised your client. The client must have approached you and you asked him to file a representation. The remedy lies elsewhere. And you know that that delay cannot be condoned. Also, that is law, that 45 days period. So all these things are there.
My lord, with your permission, my lord, bank
We
might
are
have.
granting you permission, you take reports, we will not, like, this writ petition has been
Mr.
filed.
President, then let it come next week so that I.
No question of development.
My lord, so that my lord, development what happened, my lord, in the
Which
meantime.
development, for a direction to pass the
The
notice.
settlement है my lord, between the bank and
Pass the
settlement
notice
है.
dated 2/5/2025. The order dated 2/5/2025 passed by the London District Magistrate Ganjam under section 14 of the SFSI Act. It appears that the petitioner, instead of approaching the London DRT, which is the proper forum to challenge such order, has filed a representation under Annexure 6 on 13/5/2025. In view of the settled position of law as decided in case of sejudicial soda building, since alternative remedy is available to also, it is open to the petition to seek such remedy.
My lord,
Not expressing any opinion on the merits of the case, Mr. Ramchandra Panigai, Land Counsel for the ICICI Bank is present. Accordingly, it is disposed of. Yes, next.
my lord, हम अभी तो settlement सॉल्व के dispose है जो.
It's example.
Your lordship, that observation, lordship, that.
The London Council for the petitioner submit that the matter is likely to be amicably settled between the parties. It is open to the petitioner to raise all such funds before the alternative.
No, before the bank, my lord, वाले में settlement है जो.
ठीक है शापुन जान.
मैं या तीन हजार मिलर बैंक मत कोई दो बैंक.
You have been telling that since last 4 hearings. This
Yes,
is fifth hearing.
Item number 5.
Five.
है जो ना my lord, that पर भी सही मिला.
All right, item number 5.
Both the party agree, my lord. My lord, I will permit to bank to approach permission.
Item number 5, you will not. Item number 5. Please look at it.
Then the Kinder's Jeffrey Mellon and filing the memo.
Mr. Maharana Mellon was to take instruction. Without my consent, power line has been given to my tenant. There was the existing.
Just a minute. Mr. Santanu Kumar Sarangi and senior advocate filed the appearance by this statement. Mr. also made that he has instruction to appear on behalf of the opposite parties number 1 and 2. Executive sponsor and sub-regional sponsor from submit that he will serve as full copy of the resolution and Mr. Maharana during the course of the day. Indicating upon the day the copy. Yes. So have you taken instruction in the matter? Yes.
Well, it's in this matter, the agreement for sale of a particular building was executed by the petitioner in favor of the private opposite party. Basing upon which the private opposite party approached the GRF for a connection without impleading the petitioner as a party. The GRF directed us to give him connection. We gave him connection pursuant to the GRF's order. Thereafter, the present petitioner challenged that order before this honorable court. This honorable court disposed of the matter, granting liberty to the petitioner to work out his remedy in an appropriate form. Thereafter, the present petitioner approached the ombudsman, the higher forum, against the connection which we have given, without impleading the petitioner in the GRF as a party. So he never made him as a party in the first round of litigation.
No. Who is this petitioner?
The petitioner is the owner.
Landlord.
Landlord.
Okay. Landlady.
Landlady. Opposite party number 5, the private opposite party is claiming a right by virtue of the agreement for sale.
Here, I think it is opposite party number 4. That's fine. Yeah.
No, there is a slight change, my lord, in this situation. In fact, there was a electric connection was there. The opposite party number 4 approached the GRF for a power connection, for a 3-phase connection. So without taking my consent, the GRF allowed it. and they provided it.
No, what he says that, why have you not implemented that,
In appellate stage, in
in
ombudsman.
the, before the ombudsman?
That seems to be
She
a.
could not be, now you are making a party. So she could have also had a say before the ombudsman. That was not.
Yes,
done.
that's right, Your Lordship. That is something I should have done.
Dispute is something else.
Without,
No, that agreement is cancelled. Forgery is there, then very many aspects are there.
This is arm twisting.
Yeah,
This is arm twisting.
police wala is my tenant. And there is a status quo, civil court property also, injunction is there.
All these things could have been brought if the opposite party number 4 would have
right.
made
That
him as a
even-
party in the first
even
If Your
place.
Lordship feels it that way, let me go back to the
Yeah.
ombudsman. I'll file also a better application if required. Better.
Let's, if I may submit. In the first round is the GRF. GRF, he was not implemented as a party. In the ombudsman,
Why you do one thing, you just file a 2-page that objection that why
Yes.
you are telling, so that would be a ground for us to pass an order that let him go there and make him or a party and or everything would be now orally.
I will do it. And my
Suppose you set aside GRF order and it is some right is accrued in favor of.
Then it's a problem.
He has to be heard.
Yes.
Without that, we can't set
Yes,
aside.
my submission was, instead of ombudsman taking up the issue, the original authority, who is
Because
the
once we issue notice in this matter, this opposite
Yes.
party number 4
Yes.
will come and say that, sir, we are not,
Yes.
I am not been made a party.
Yes.
I'll file a short objection on this.
So we are taking up this matter. If you say we can take up next week, just file, you can.
I'll file it in the meantime.
Put up this matter, Mr. Maharana, Ladit Maharana, Land Council, appearing for opposite parties number 1 and 2 submits that in pursuance of the order dated 13/10/2025, he has received the copies of the writ petition and the matter may be taken up. A week after, he will file the objection to the writ petition. Preliminary objection to the writ petition and put up this matter on 10th of November. So that, yes.
Item 6.
In this matter, on behalf of the bank, a short affidavit to be filed. Short affidavit to be filed.
You are for the
Bank, my lord, it is the
Union Bank of India.
My lord. Here the status of the petitioner before the lord is the leaseholder person who is under the, by virtue of the lease deed agreement, he is holding some right and now he has filed this writ petition. But after amendment from 1st September
What is the
2016.
prayer of the petitioner in this writ petition?
Well, it's the goods and articles that belongs to the petitioner.
Yeah.
That has to be written. That is why I have filed a detailed representation before the bank on 1st of April 2025. And that has been rejected on annexure 5 on 16/6/2025. Therein,
On what ground it has been
they have stated that we are not a PV to the lease agreement. So please approach Polingo Polyplex Limited. Now the property, the goods and the articles that doesn't.
What
form-
are the goods and articles? What kind of?
That is the machinery and parts that I have stated.
Lord, with permission, regarding the leasehold right, also be decided in the tribunal after amendment from 1st September 2016. Otherwise, I will file a short affidavit to this. Please.
So let him file that affidavit, what is Mr. Sahoo, Land Council appearing for the Union Bank of India 1 week time to file an affidavit in connection with the case and brief format, and then leave this matter on 10th of November 2025. Affidavit, if any, be filed in the meantime, shall be a copy and the land council for the petitioner. Yes.
Obliged.
Item 7.
Item 7. Well, there is a noting that the impugned order which has been challenged before the Supreme Court is not filed. In fact, it is filed and it was filed on 2/9/2025. But it has
লেখা আছে pursuant to the order dated 28/7/25. 28/7/25 জানো?
Yes, my lord. That
The writ petition has been filed by the so-and-so challenging the order dated so-and-so. Land counsel for the petition submit that in annexure 3, a wrong order has been annexed and he may be given some time to file the correct order. So have you filed that?
yes, well, that I have filed, that is filed on 2/9/25. Probably it is not on record.
আচ্ছা লিখুন মিস্টার মিশ্রা লাইন senior panel counsel appearing for Union of India submits that pursuant to the order dated 28/7/2025, he has already filed the correct order passed by the correct impugned order dated 17/1/2025 on Quebec
2/9/25.
2/9/2025. But the same has not been placed on record. Let the registry place the same on record. Matter will be listed on 31st also. 31st of this month, 31st/10/2025, with like WPC number 21566 of 25 and 23042 of 2025. Yes, as a year like they will learn counsel for the opposite party as present, na? Mr. Sopan Kumar Ojala. Yes, next.
Item 8.
Item 8, members, on the last occasion, your lordships wanted to see the sale certificate in the matter.
This petitioner has challenged the eviction notice under annexure 1.
Just a minute, Deepankar Acharya and counsel appearing on behalf of submits that he has received the copy of the from the land council inspection that the auction sale is successful and the sale certificate has also been issued.
Yes.
The matter is taken as charge. So the sale certificate is in your favor.
Yes, no, my lords, I am for the bank, my lords,
you are
on behalf of
bank.
Mr. Arpan Annadas.
Okay, who is for the you are for the
Petitioner,
borrower. So what you are challenging now?
I have challenged the eviction notice issued by the bank on the basis of a non-existing order of the district magistrate. Initially, the district magistrate passed the order on 29th.
Whatever it may be now, we go to the alternative.
And go to the alternative, but
So why will you waste time here?
I am
It is
sorry
not
to
maintainable.
district one sentence, my lord. The district magistrate passed the order on 10th March 2022 as per 29. He has withdrawn the said order, being the property belongs to Jagannath Mahaprabhu and Amruta Manipur. The said withdrawal order at page 22, annexure 6. When the order is non-existing, the bank is proceeded to take physical possession by making deposit.
Now the situation is different now.
The situation and sale certificate has been issued that I will challenge before the DRT. I have the available. But how they issued such implement order is in the non-existing.
Sale certificate has been issued in favor of Mr. X. Right has already accrued. You are not making him a party.
I don't know to whom this is.
বর্তমান তো জানিলে না নাই
I have given a copy of it.
Is it not ଆପଣ ଏ 2024 ର ଅର୍ଡର ଟା ଆପଣ ଜାଣି ନଥିବେ ବୋଲି ଆପଣ 2025 ରେ କହିବେ ସେଟା
That is purely departmental.
ଆପଣଙ୍କ ପ୍ରପର୍ଟି ବିକ୍ରି ହେଇକିନି ଥାର୍ଡ ପାର୍ଟି ଇଣ୍ଟରେଷ୍ଟ କ୍ରିଏଟ ହେଇ ସାରାଣି
That is
ସେଲ ସାର୍ଟିଫିକେଟ ଇସ୍ୟୁ ହେଇ ସାରାଣି
internal communication between bank and କିନ୍ତୁ ସେ non-existing order ରେ ସେ କେମିତି proceed କରୁଛନ୍ତି? They have made the deposit before the police.
Approach the the Learning Council for the banks has filed the sale certificate, which is dated
26/6/2024.
2024. and the same is taken on record. Since in the meantime, third party interest has already been created and the petitioner has brought alternative remedy to seek necessary relief, we are not inclined to entertain this petition. Accordingly, the petition is disclosed, giving the the petition has been filed by so and so, praying for so and so. Yes, next.
Item 9.
Please, my lords.
Yes, may it please, Your
My lords, I am appearing on VC, my lords. I had taken my lord's permission on Friday.
Yes, Mr.
My lord, we have challenged the order of the Law and Sentence Tribunal under Annexure 1. That is the order dated 31/1/2025. The relevant person is coming. Page.
What was the prayer of the applicant before the learning tribunal? What is the OA?
Yes. The OA.
Have you annexed the OA copy?
They have not annexed, my lord. We have not annexed that time, my lord.
My lords,
at the time of filing.
by order dated 15th October 2025, my lords had given a direction that the OA copy has not been filed, so therefore that may be filed. However, since my learned friend has not filed, we have kept the copies ready.
Achha, please, where is that copy?
My lords, Mr. Bishoy can pass on the copies, my lords, to my lords.
No, how we can?
My lord,
What happened?
The problem is that everything is scanned. This particular document will not be
because the
scanned.
the learned tribunal is not provided the copy of this.
How these people have got it?
They are the petitioner.
They are the petitioner. You file the counter.
You file the counter affidavit.
My lords,
you say that you file the counter affidavit.
Now we have a copy from the tribunal.
All right. Now the thing is that now it is to be scanned and it should come in a proper form, not that the part of it will be in.
My lord, is still henceforth we are instructed all the council they are filing. We counter everything is the time of filing the petition. May I read the relief sought for before the tribunal by the petitioner?
Where is that? What is the page?
That is page internal page 17 of the OA. Relief sought for.
Annexure 1.
Yes.
You have a copy with you.
I have a copy now.
Except the original application.
Annexure 1 is.
You had a copy, you should have filed it. Original
application.
We are not venturing into where from you got it, but the fact remains that you have a copy. You should have filed it.
Original application ଟା ଏମିତି ଗୋଟେ ଫାଇଲ କରିଦେଲେ ଆପଣ କପି ପାଇଯିବେ ନା ତାପରେ କାଉଣ୍ଟର ଦେଇଛନ୍ତି ସାର୍ଟିଫାଇଡ କପି ହେଲେ ଆପଣ ସେ ଦେବେ ନହେଲେ ଆପଣ ଦେବେନି
2 ବର୍ଷ 3 ବର୍ଷ କାଉନସିଲ ଚେଞ୍ଜ ହେଇଯାଉଛନ୍ତି ସେ ଫାଇଲ କରିକି ସେ ରାଞ୍ଚିରେ ଫାଇଲ କଲେ ସେଠୁ ତାପରେ ଏଠିକି ଆସିଲା ଏଟା ଆହୁରି କମ୍ପ୍ଲିକେସନ ହେଇଗଲା.
So this the prayer was to quash this annexure 1.
Yes.
Annexure 1 ଟା କୋଉଟା ଏରେ କୋ ନମ୍ବର ଫମ୍ବର ବି ଦିଆ ହେଇନି.
Annexure 1 my lords is page 21.
अच्छा, this is annexure 1 टा ଲେଖା ହେଇନି କି annexure 1 କୋଉଠି. Please read it out. Mr. Pani?
Yes. Call for the annexure 1. Yes. Memorandum dated 26th April 2019 with reference to the representation dated 16/12/2018 for counting IDVC project service of the pensionary benefit. Dr. Manoj Kumar Das, scientist E, is hereby informed that the matter was taken up with the council, which viewed their letter number such and such dated 13/2/2019 has reiterated their earlier stand stated via letter number such and such dated 11/10/2018 that there is a defined procedure for continuing of counting of post service rendered on contract basis under the CCS pension rules. The project employees are not considered as a government employee
As such, there is no provision for fundamental rules for pensionary benefits without regulation of service from the date of initial appointment. The copies of ICMR letter dated such and such at 11/10/2020 referred to above are enclosed for your perusal. What happened in this case, my lord? I'm just clarifying, my lord, what is the position of law? If there is no dispute, he was.
Just come to the, this is the first prayer. But the second prayer is so that direct the respondent to count his service from 4/1/1988 to 15/3/2007 rendered in NIMR
under the
IDVC project as qualifying service for the purpose of pension and other retirement benefits. So that is also the
another prayer.
Another prayer. Yes, now this has been torn down.
Lordship may come to the next prayer also. They direct the respondent to give all consequential benefit based on the prayer above. There are threefold prayer they have. Here the basic question is, the person those have get regularized by the organization by the virtue of the order of the Honorable Court.
What is your, let us say, what are the grounds taken for claiming such a relief? In which are the relevant paragraphs of the original application which deals with that for these reasons the petitioner is entitled to for a counting of his service from this particular period. What are the main paragraphs?
Petitioner's ground by
1 minute.
My lords will find the grounds from page number 12 of the OA.
1 minute. 1 minute, please.
My lords.
You have given it in Delhi, Jharkhand, Punjab and Haryana, everywhere.
Yes.
Why are you singling out this person? That's what the tribunal says. You have to pass a uniform. You are Union of India. Why are you doing this?
My lord, no. This case is not compared with the other cases because I'm
Same
just
project kindly.
this project. Yes, I'm
page
just
23, page 23, 4.1. Read it. And at 4.2. 4.2 rather.
4.2. It is submitted that the pursuant to the order dated 23/2013 of the High Court of Delhi in WPC number 1554/2013, such and such, the service of IDVC projects.
Same project.
Yes, same project. We are not equating. We are regularized, that is from date of their appointment, by creating equal number of temporary posts for personnel to the officer concerned, for whom the posts were created and the said post got abolished under their upon their retirement, confirmation and regular appointment to other posts or for any other reasons. What discussion here?
Read further.
Yes. That the cost of the reputation, Land Council for the respondent stated that since the applicant, after submitting resignation, joined in the post of senior research officer, he is not entitled to count the service rendered under the project or temporary or ad hoc basis, and hence the OA being devoid of any for dismissal of OA. After giving due consideration to the arguments advanced by the parties, we have gone through the averments made in the pleadings and documents placed in support thereof, including the decision referred to above. The decisions relied on by the applicant are detailed as under. In the case of Mahesh Chandra Verma, so the question of consideration before the Honorable Apex Court is to be whether the service rendered by the Mahesh Chandra Sharma as judicial officer, fast track court, are liable to be continued in pension benefits of the post of joint judicial services. However, the Honorable Court, after bringing the reliance of the various decisions, have held that the applicant, along with all judicial officers identically situated, are entitled to get benefits of their service rendered in the fast track court detention of the This is completely different, my lord. That judicial service also I am conducting here for the private parties. We have taken benefits because the pensionary benefit is given to ad hoc service, and after that service, that is counted at 2004 or after, if they are before 2004.
Para 11. Read
Yes,
para
para 11.
Page 28.
Yes, madam.
All the cases are discussed thereafter. In the case in hand.
Yes, ma'am. In the case in hand, the counter also in course of the hearing, it has been submitted by the respondent,
Admitted by the respondents that the compliance of the order of the Honorable High Court of the Judicature at Madras, Chennai, and the Honorable High Court of Delhi, similarly situated employees and engaged in the IDBC projects were regularized, that is from the initial engagement of the temporary and ad hoc services. It is also not in dispute that the pursuance of the advertisement made by the council, the applicant, while continuing under the same respondents as senior research scientist, submitted application through his employer ICMR for the post of senior research officer under the ICMR, and after being selected through the regular process of selection, he tendered his technical resignation by the application dated such and such, application dated 15/3/2007, and therefore thereafter in the application dated 16/3/2007, he had intimated that since he has been posted at the field unit and working as a officer in charge as such, he may be treated have joined in the post of senior research officer. From the above, it is established that the duties discharged by the applicant as a IDVC project as a senior research scientist on temporary and ad hoc basis was same and similar to that of the duties after his joining to the post of senior research officer. After joining, he was allowed protection of pay to the post of senior research officer under FR 22, as stated by the applicant, has not been disputed by the respondents. The respondents have stated that since the applicant was continuing purely on temporary and ad hoc basis under the project, his plea that he is earned in the post of senior research officer after tendering technical resignation is not acceptable as per the deputy office memorandum dated such and such dated 17/8/2016. But he finds that this plea has been taken by the respondent for the first time in the counter without any supporting documents to the above effect. After submission of technical resignation by letter number dated such and such 15/3/2007 and joining report dated 16/3/2007 in the post of research officer, the applicant was allowed to continue in the post of senior research officer by respondents, granting him all the benefits, including the protection of his pay and technical upgradation by order dated 19/6/2013, and thus when the applicant prayed to continue the period of service, count the period of service which had rendered under the IDVC projects for the purpose of pension and pensionary benefits, denying the same on the ground that his resignation cannot be treated as a technical one, is in an afterthought and is not acceptable in the eye of law. Then my lord, the only thing is you admit everything. The only thing what you are saying is on 15th he resigned, on 16th he rejoined. Even after giving the pay protection and everything, you say that we will not give the benefit of the past service. That's what you are saying.
No. What you are saying, my lord? One second, I am repeating, my lord. He was joined in the 88 in that particular project, in another post. Again, he joined in the research officer in another project for the particular time. He was discharging similar nature of work, it is admitted, but not the particular post and particular work. He tendered his resignation because his regular post is qualified. So those persons have not qualified or not eligible to the post. They have been regularized because of the court's order.
The people,
post has been created.
I'll tell you what had happened. The people, those who were working in ad hoc post, subsequently regularized. What you are saying is the people, those who are ad hoc, working as an ad hoc and regularized, they will get the benefit of that past service. Okay. But in this case, what had happened is he was working in ad hoc post, but regularly appointed. So therefore, he resigned on 15th and on 16th he joined. Therefore, you say that the service is discontinued. So we will not count for the.
No, my lord. That's why,
what you are saying.
that is not fact. This is the case we have given permission. Those persons are only regularized. They are confined to only their regularized and getting their pension.
Then why have you protected his pay under FR 22?
No. Here is a case. He given a resignation, joined in the post. We have given treated as a regular employee and given promotion. He is promoted to very high level. He is protected with a very senior level post with a pensioner benefit of that retirement benefits. Those people are regular. They are not getting Sahoo. They are only regularized on the same post based on the court's direction. Supervisory post has been created. Government has, according to the court's order, their protection has been given. They are given pension, SCP, SCPC, whatever they are entitled to, they are given. More than 10 years service, they are getting. Here the process it is not. His recurrent process was continuing. He has applied for them. He was selected. Then he resigned from the previous post as a project. Then he joined newly, and thereafter he is treated as a regular employee. Thereafter he is given promotion and get the 5 promotion in this 3 promotions, and he is getting benefits in this regard. Those who are not getting by others. So he cannot similarly treated as a person who is only regularized and got their benefits. That's why in this Phyllis Hon'Ble case in Madras, Chennai High Court.
Yes, Mr. Behra, how do you justify what clear you have after resignation?
My lords,
How do you continue the Leon?
How do I?
That's the only question he is raising.
How do
you have a Leon after resignation with the past
on the
head of
resignation? My lords, the question of a resignation is a technical resignation. If my lords have a look at the page number.
What he says is once you resign, you have no Leon.
I am answering that. I am answering that, my lords. If my lords may have a look at page number 163 of this new writ petition, my lords. Page number 163, which is a part of their counter before the learned tribunal. This is the office memorandum which governs the issue of technical resignation and counting of past service. Now, my lords, may kindly permit me to read the first 2 paragraphs. This is an office memorandum dated 17th August 2016. My lords may take the note of the date at the top. Kindly take note of the date. Subject is technical resignation and lien consolidated guidelines. The undersigned is directed to refer to the departments of OM of event number dated 26th December 2013 on the above subject, and to say that the guidelines instructions regarding technical resignations have been issued from time to time. It is now proposed to further consolidate these instructions as the department continues to receive frequent references in these issues. Now, my lords, kindly see paragraph number 2.1, technical resignation. As per the Minister of Finance OM number so and so dated 17 June 1965, the resignation is treated as a technical formality where a government servant has applied through proper channel for a post in the same or some other department and is on selection required to resign the previous post for administrative reasons. The resignation will be treated as technical resignation if these conditions are met, even if the government servant has not mentioned the word technical while submitting his resignation. And then kindly see the next sentence. The benefit of a past service, if otherwise admissible under the rules, may be given in such cases. And thereafter, my lords may also see. And thereafter, my lords may also see Rule 13 of the CCS pension rules. Rule 13 of the CCS pension rule is one of the grounds which the learned tribunal has relied upon to grant me relief. And this rule has been.
Behra,
my lords.
Mr. Behra.
My lords.
This letter which you are referring to
yes.
is dated 17th August 2016.
Yes, my lord.
Your technical resignation was on 15th 2007.
Correct,
so
my
at
lords.
that point of time, what was the
referred to 17 June?
This is only a consolidating OM. This is this office memorandum of 17th August 2016 is a consolidating OM.
17 June 1960.
In fact, my lord, this office memorandum has consolidated all the instructions which have been issued from time to time on the issue of technical resignation. This is not a office memorandum which was issued for the first time on 17th August 2016. And in fact, my lord, this is a document which has been
1965.
Yes. And this is
It
not a
is
document
listed,
which has been
Sir.
filed by me. This is a document filed by the respondents in their counter affidavit before the learned tribunal. This is a part of the counter affidavit filed before the learned tribunal. That means for the purpose of technical resignation and argument based on technical resignation, the respondent themselves are relying upon this office memorandum, this consolidating office memorandum.
That means the benefit of the past service, if otherwise admissible, under the rules may be given in such cases.
Yes.
No, but if he is a government servant, he is not a government servant given technical resignation done here.
My lord,
This office
if I was
memorandum, if a person is a government servant in government capacity, their technical resignation will accept it is another technical government service. Here is a case, he is completely in a project, he is temporary in nature. This this benefit cannot be extended to him. That's why repeatedly this office memorandum said that government servant.
My lords, if I was not a government
anybody
servant,
in a government servant and given this technician, he is joined in another government service, then this circle, it is a mere technical resignation. Here is a completely is a project, he is a temporary in nature, he is a complete.
The original application has been filed by the land council for the opposite party, which is taken on record. Mr. Pahit and an Deputy Solicitor General appearing for the Union of India submitted that though the Land and Tribunal has mentioned in the impugned order dated 31/1/2025, passed in OA number 260/00692 of 2022, that similarly situated persons engaged on temporary ad hoc basis under the project have been regularized from the date of their initial engagement, and the whole period has been reckoned for the purpose of pension and pensionary benefit. But the petitioner is not similarly situated. The Land Council submits that the what is that say technical year jota padutila hoga
Page 163.
163
17th August 2016 office memorandum.
Okay, etc. That the petitioner's prayer before the Land and Tribunal inter alia was to set aside the order dated 26 April 2009 and for a direction to the petitioners to count his service from 4/1/1988 to 15/3/2007 rendered in NIMR under IDVC project as qualifying service for the purposes of pension and other retirement benefit, and for the further direction to the petitioners to give all consequential benefits to him. Though the technical resignation has been stated as stated in the office memorandum dated 17 August 2016. By consolidating the guidelines of the instruction regarding all the technical resignation issued from time to time, and it states in paragraph number 2.1.1 as follows, quote kar dena, which a party submits that relates to applicable for a government servant. But in case of the petitioner, he was working under a particular project, and he has tendered his resignation on 15/3/2007 and joined in the post of senior research officer on 16/3/2007. And therefore, this particular on 63. The recital of this office memorandum dated 17 August 2016 would no way be helpful for the petitioner to get the relief sought for, which was granted by the learned tribunal. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission, since the opposite party has already entered appearance. Matter will be listed on 24th of November 2025. In the meantime, the counter affidavit, if any, be filed by 17th of November 2025, serving copy on the Latin Council for the petitioner. It is open to the petitioner to file their rejoinder affidavit if they so desire by 20th of November 2025, serving copy on the Land Council for the opposite party. Yes.
My lords, may I take note of this fact? My lords,
the interim application
623
IA number so and so. Our order te heat
interim order, not
order
taken any policy.
already an interim order.
24
Acha 24/10. The interim order which has been passed relating to the content petition which has been filed before the Land Central Administrative Tribunal shall continue till the next day.
my lords, since my lords are continuing this, then in that case, can it be, my lords, put before 24th, my lords?
Advocate for the opposite party. Yes.
My lords, can it be listed before 24th?
Inside name also you must write.
Yes, Mr.
My
Behra.
lords, can it be, since my lords are continuing the interim order in the content petition and the opposite party is my very senior citizen, having retired in the year 2019, if my lords can,
24th, we are to at least give 1 month time to complete this pleadings things.
my lords,
Because you are to file the
I do not propose
counter,
to
he
file
had
any
to
counter.
file the.
My lords, I do not propose to
No,
file any
it's,
counter
all right,
affidavit.
but-
My lords may record that statement because all the things are on record. My lords have already taken my way on record. So therefore, my lords, I am not filing any counter affidavit. So the process of counter and rejoinder may be dispensed with. If my lords want only the argument points, I can file for the purpose of my lords consideration along with the page number. That in that case, nothing is required, and my lords may prepone the date.
Mr. All right, Mr. Abhay Kumar Behral and senior advocate submits that the opposite party doesn't want to file any counter affidavit. And you will just file a written note of submission, and therefore the matter may be taken up a little early. So you agata kati de likhiwe. Is this matter on 17th of November 2025? Yes.
7.
Come with written note of submission.
Yes, I will file that, my lords. Please, my lords.
We are just coming within 2 minutes.
filed the copy of the OA, but it's not that to the.
Item 10.
I am sorting one copy. Council for the Union of India. Kindly keep you on 29th or 30th.
Item number 10.
I have filed on 24th, it's not that.
OA, copy of OA.
Mr. Punya Land Council for the petitioner submits that he has already filed the original application which was filed before the Land Central Administrative Tribunal Cuttack Bench on 24th. On 24th of
My daughter, 29th of this, 29th or 30th.
last month.
No,
Then upon
when did you file?
24th October.
24th October.
24 month 5 days. 24th of October 2025. And the same may be tagged to be filed. Put up this matter. So we can take up this matter this week itself.
Yes,
on 31st of October.
my daughter, 30th, keep it 30th. Keep it on 30th.
30th, there is a different bench on Tuesday and Thursday. The bench is different, so any.
Larger bench matter.
You tell us another date on Monday, Wednesday and Friday.
Monday,
then 3rd of November 2025. Yes.
Item 11.
Counter affidavit for bank, my lord, last order may kindly be seen.
On 17/10/2025, your lordship is directed to state to take instruction relating to section 14. Possession of the property.
When?
On 17/10/2025.
Last order may kindly be
Just,
seen.
just.
1710.
Last but one paragraph, my lord.
Land Council for the state shall apprise this court as to why possession of the purchased property has not yet been handed over to the petitioner, even though the petitioner is the successful bidder and the sale certificate has been issued in her favor, and direction of the collector, Jajpur under section 1. Yes.
We have to provide that. Date reschedule has been fixed to 1/11/25.
Some copy to the
Again.
The Land Council for the state has produced the written instruction dated 25/10/2025 of the sub-collector Jajpur, which shows that the executive magistrate has been deployed to remain present during physical possession on 1/11/2025 by this office so and so dated from. The Land Council for the opposite party number 2 has filed a counter affidavit which is taken on record. Put up this matter on 10th of November 2025. The Land Council for the state shall apprise the court about the development.
Bank to cooperate so that things can.
My lord, can I pray just 11th, my lord, 10th?
11 se hoboni para amano
12th.
on consensus like those 12 11
Obliged.
2025. Yes.
Only direction bank has to cooperate with.
Bank has
It has to cooperate, my lord. I have shown the sub-collector's order. He's acting as appellate authority saying essay is pending. I have given the essay pleadings.
We have noted down all the details also noted down in the that order.
Previous order is very clear of
Now
lordship.
sorted out.
Yes.
Item 13.
Yes, Mr.
My lord, I pray for an adjournment, my lord. There has been some development in this case, so it might we might have to file an amendment or have to withdraw and file a fresh. So 1 week time maybe we can take instructions.
Here everything is over. Why are you challenging it here? You are the debtor, no?
Borrower, you are the borrower.
You are the
No,
borrower.
I have, actually, my lord, the petitioner herein has entered into an agreement to purchase from the debtor, from the borrower.
Then you file a specific performance, not.
So there is a certain thing,
No, these petitions are.
one adjournment is filed.
The writ petition has been filed by the petitioner.
Prayer number 2 is specific performance.
Yes, my lord. Actually, the petitioner
we-
herein is ready to clear all the dues and
Court code for them.
one adjournment, my lord.
ABC.
Options.
It appears that
So when the writ petition was filed, the option notice is not there. Now the option
simple
notice has come.
position. The notice has been issued to the Nilachal Engineering Works, Messrs. Nilachal Engineering Works, to pay the dues within 30 days of the receipt of the notice. That is notice dated 2/6/2025. Otherwise, the right of redemption of the property would be extinguished after publication of the auction notice of the secured asset. It is the contention of the Land Council for the petitioners that the property which was mortgaged with the bank has been transferred in the favor of the petitioner.
No, only agreement.
By an agreement has been
Agreement.
executed by Messrs. Nilachal Engineering Works.
Yes, my lord.
In
The
favor of the
owners
petitioner.
are.
After going through the pleadings and the documents, since we are of the view that in view of the settled position of law as held in so and so, since alternative remedy is available, and to the aggrieved party to challenge the action of the bank, we are not inclined to entertain this writ petition, which is accordingly dismissed. Yes, next.
In that case, may I pray, my lord, may I withdraw the matter? It might be, if he wants to participate in the tender, in the auction, then it might be a problem.
We do not know. So and so, at this stage, present last of activity. At this stage, the Land Council for the petitioner seek permission to withdraw the writ petition.
I'm grateful, my lord.
Yes, next.
Item 14.
In this case, in this case, the petitioner assels Lordship, impugned order is at page 13. Lordship, in this case, the petitioner assels the order dated 26/9/2025, passed in OA number 654 of 2024 by Learned Central Administrative Tribunal, where the Learned Administrative Tribunal has rejected the petitioner's seeking the intervention to not to transfer from Bhubaneswar, GSI Bhubaneswar to GSI Nagpur, because of, let's see, the petitioner is was suffered a spinal cord injury, Lordship, and partially his lame, and not able to even travel long distance. And another thing, the petitioner old mother, she is a chronic liver kidney patient and getting treatment at Bhubaneswar, Lordship, and she is more than 80 years old. And apart from that, his only daughter
he is pursuing a course at Bhubaneswar. So in the mid academic session, so that will be a great
So
problem
all
for him.
those decisions that this is an administrative order, this court should not interfere in the matter of transfer unless it's a condition of service. This has already been discussed and
Lordship, I oblige Lordship, but Lordship may protect me till month of March.
No.
So that my daughter.
Have you got any vested right to remain in that court? You are in service and you are required to be transferred. So what is the malifiedness behind it? And whether by purpose of this transfer you are going to be placed in a lower post or something like that. It's nothing, just you are taking your personal ground that my son is reading this, I have this health issue, all these things.
In the month of March, I may be.
You have a right, then
month of March.
if you have a right, then you can get it enforced through court. You don't have a right, it is a condition of service. It is again a sympathetic consideration by your higher authority. You have to impress upon your higher authority, not transfer you, that's all. No court can interfere with those side of things. That's the difficulty. Even the court have sympathy, the court can't do anything.
Lordship, till month of March, Lordship.
No, this writ petition has been filed by the petitioner, Umakant Naik, challenging the order dated 26/9/2025, passed by the Land Central Administrative Tribunal, Cuttack against Cuttack, in way number such and such. The original application was filed by the petitioner to quash the order number so and so, it are page number 48. In transferring the petitioner from such and such, the opposite parties entered appearance in case and filed the counter affidavit, and specific stand has been taken as follows. Quote the relevant paragraph. The petitioner filed a rejoinder affidavit. The land tribunal, after considering the pleadings of the parties and
You can also observe that previously case was also considered and thereafter.
pleadings would have the counter affidavit relevant paragraph would have forced further. And taking into account the ratio laid down in the case of securitization, wherein it has been held that transfer is so and so, so and so. And has been pleased to held that that the order of transfer has been passed in the exercise of it cannot be said that the order of the transfer has been made in exercise of tolerable or malified exercise of the power. And since the transfer is an incident of service and guideline has been laid down for affecting transfer, not being enforceable condition of the service, an order of transfer made in violation of such guideline by itself does not furnish the ground for interference. So, the Land Council for the petitioner argued that at least the petitioner may be permitted to continue till March 2026 as the children are to appear in the final exam, and the petitioner has got some health issues. we have that such grounds are not sufficient to interfere with the transfer order. And rightly, the London Tribunal has relied upon the ratio let down by the Honorable Supreme Court in the aforesaid decision. And we also find there is no illegality or infirmity in the order of the London Tribunal according to the reputation of the Board of Lawyers.
Item 15.
Along with Mr. Sethi is appearing in MS.
Evening.
Item 15, Your Lordship. On behalf of Senate Counsel, Mr. J.R. Gora, Your Lordship.
Yeah.
Lordship, on last occasion, this matter was heard on 12th, Your Lordship. Your Lordship directed me to file a chronological date chart, Your Lordship. Filed. So, in copy that. What is it?
What is your prayer in this petition?
Obviously, you have to read the period. The petitioner has been, Your Lordship, subsequently removal from service as if he was working as section officer, Your Lordship. Lordship, the peculiar facts of the case, Your Lordship. The opposite party authorities, right, order dated 24/3/2009, page 16, annexure 5, Your Lordship. Reverted the petitioner.
You just come to the place your date chart, let us see.
Your Lordship. In 1978, the arbitration tribunal was created on the Irrigation and Power Department, Government of Odisha, without giving any definite status, and the office was functioning under the Irrigation and Power Department. In the same year, one post of Lower Division Assistant, LD Assistant, and other posts were created. On 8 January 1980, annexure 1, page 11, the District Employment Exchange Officer was asked to sponsor the name suitable candidates for the said post of LD Assistant, one post. However, on 1st January 1980, the Employment Exchange sponsored the name of 17 candidates, including the petitioner. The name of the petitioner finds place serial number 1 in annexure 2, page 12. In the meantime, Your Lordship, in between 8 January 1980 and 24 January 1980, on 19 January 1980, the Arbitration Tribunal was declared the head of department. Lordship, as per the OMS rule 1975, any recruitment under the head of department has to be made through OMS rules, Your Lordship. However, as the recruitment process was started before the Chairman Arbitration Tribunal was declared head of department, the recruitment process was carried out. And subsequently, a written test and an interview was conducted. And on 4th February 1980, the petitioner was selected and appointed for the single post of Lower Division Assistant on the basis of the said written test and interview. On 29th February 1980, the petitioner joined the said post of LD Assistant. After 4 years, on 25/4/1984, opposite party number 3, private opposite party number 3 was appointed. On 18/3/1985, the Chairman Arbitration Tribunal, while later dated 18/3/1985, requested the FA cum Deputy Secretary to Government, Irrigation and Power Department to regularize the service of petitioner under OMS rule by virtue of Rule 14, relaxation, indicating all reasons and mistakes connected. Your Lordship, kindly have a glance to that letter. Your Lordship. That is important. Your Lordship.
Read the
Complete. Yes, next.
Lordship, that what I humbly submit, Your Lordship, that annexure 7, they have clearly written the mistakes they have committed, and then
go through your list.
Please complete the list, then we'll.
Your Lordship. On 18/6/1985, the the FA cum Deputy Secretary to Government, Irrigation and Power Department, with reference to the said letter earlier given by the Chairman Arbitration Tribunal, regularized the service of the petitioner from the date of initial joining in public interest, the reason being public interest, and by virtue of relaxation provision Rule 14. After relaxation or regularization,
On 11/7/1985, the petitioner was promoted to senior assistant. It is pertinent, also, Your Lordship, the OP number 3 had nowhere or ever submitted any objection to the said promotion of the petitioner to senior assistant. On 28/10/1995, a provisional gradation list was circulated in the rank of senior assistant, inviting objections, if any. The name of the petitioner was a serial number 1 and the OP number 3 was a serial number 2. By then, the petitioner completed 10 years of service as senior assistant. However, no such objection was ever received or submitted by OP number 3, challenging the said provisional gradation list. On 19/12/1995, as no objection was filed by OP number 3 or any other person, the said gradation list was made final. The petitioner, on 1st January 1996, the petitioner completed accounts training and cleared the departmental test and was eligible for consideration for promotion to the next higher post, that is section officer. On 1st January 1996, the DPC found the petitioner suitable and recommended the promotion and was promoted to the rank of section officer level 2 on the same date and continued to serve till the impugned order dated 14/3/2009. On 17/3/2009, for the first time, on the representation of the petitioner, after a long delay of 13 years of finalization gradation list and 23 years delay of regulation of the petitioner, the Chairman Arbitration Tribunal submitted a query to FA Department, Secretary to Government of IAP Department, that whether the representation of the opposite part number 3 is to be considered and he has to be placed above the petitioner in the gradation list that was finalized 13 years back. The FA Department, Your Lordship, directed to consider it, and the Chairman Arbitration Tribunal on 24/3/2009, without giving any opportunity for hearing the petitioner, revised the final gradation list that was finalized 13 years prior in 19/12/1995 and placed OP number 3 as serial number 1 and of the petitioner at the bottom seniority. On 24/3/2009, the Chairman Arbitration Tribunal said, order dated, further reverted on the same order, on the basis of same order, Your Lordship. Not only they placed the petitioner to the junior rank, Your Lordship, also reverted the petitioner to the post of junior assistant, the prima facie post. And as there was no such post of junior assistant, petitioner was relieved and subsequently that acted as a removal, Your Lordship, because still from the date of that reversion till the date of attending superannuation, that is on 2013, for the 5 years, petitioner remained out of service. The petitioner filed OA number 805 of 2009 before the Learned Odisha Administrative Tribunal, Cuttack Bench, Cuttack, challenging the said Annexure 5, Your Lordship. The Learned State Administrative Tribunal on 17/7/2014 rejected the said OA of the petition on the sole ground that no reasons have been recorded or cited in writing for relaxation, nor state the rule of OMS that has been relaxed in the regulation of the petitioner. And also for the wrongly interpreted that Annexure 3 as Annexure 13, the Rule 13, sorry, which states those appointed by relaxation under Rule 14 shall in that year be rank below valid reputed candidates. The petitioner was regularized in the year 1985 from the date of his initial service. So, Your Lordship, the opposite part number 3 have been recruited way earlier, way later. So, petitioner cannot be in any possible circumstance be placed below the opposite part number 3. On 3/3/2009, Annexure 8, the Learned State Administrative Tribunal, prior to passing the impugned order, passed an interim order where the Learned Tribunal stayed the impugned order and, if not already given effect to, the petitioner was allowed to place a representation to continue in the SO post. Accordingly, petitioner submitted a representation, but that joining order that was never accepted. And on the next page, Your Lordship, page 6. On 13/4/2009, the petitioner, pursuant to the said order, submitted a joining report, and that joining report was never accepted. So that on 23/2/2012, the petitioner remained out of job and without engagement, without any salary, and accordingly, the Learned Tribunal, as per order dated 23/2/2012, directed opposite part number 1 and 2 to adjust the petitioner against the vacant post of LD for drawal of his duty pay till final disposal of the OA without prejudice to his case. However, after 1 year of the said order, the petitioner, the joining report submitted by the petitioner was accepted. On 18/2/2030, the petitioner submitted joining report and requested for sanction of EOL till 30/9/2013 due to his ill health of the petitioner. On 30/3/2013, the petitioner finally attained the age of superannuation and retired. Your Lordship. And as per the also in the meanwhile, the petitioner applied a miscase, Your Lordship, before this honorable court. It is miscase number 15537/2014, in which this honorable court was pleased to allow provisional pension in favor of the petitioner. These are the brief facts of the case.
Well, the similar matter was before Honorable Apex Court. That the issue was whether the appointment of candidate made deher this rule would be regularized in exercise of power of relaxation conferred on the government by the aforequoted Rule 14 of the rule, and if yes, whether such irregular appointment, those services have been regularized under Rule 14, would be placed before the above the regularly appointed paragraph 3 minor. Paragraph 3, page the judgment page 845.
845.
In the backdrop of these provisions of the question which arise for consideration is whether the appointments of candidates made deher this rule could be regularized in exercise of power relaxation conferred on the government by the aforesaid quoted Rule 14 of the rules, and if yes, whether irregular appointees whose service have been regularized under Rule 14 could be placed above the regular appointed incumbent in seniority on the basis of length of service. The answer is at paragraph 9 onward. In the present case also, appointment of the employees whose service are sought to be regularized were deher. The Rule 14 merely permit relaxation of any of the provision of rules in public interest, but not the total severing the rules. The order do not say which rule or rules the government consider necessary and expedient in public interest to relax. What has been done under the impugned order is to regularize the illegal entry into service as if the rule were not in existence. Besides, the reason for so doing are not set out, nor is it clear how such regularization can be subserve public interest. Rule 14 has to be strictly construed, and proper foundation must be laid for exercise of power under that rule. The rule have a limited role to play, namely to regulate the method of recruitment, and Rule 14 enable the government to relax any of the recruitment of the rules permitting to recruitment. The language of Rule 14 in the context of objective of the rules does not permit total suspension of the rules and recruitment adheres the rules. In the present case, the recruitment has taken place year back in total disregard the rules, and now that is sought to be done is to be regularize the illegal entry in the exercise of power under Rule 14. Rule 14, we are afraid, does not confer such blanket power. Its scope is limited to relaxing any rules. Example, eligibility criteria or the like, but it cannot be understood to empower government to throw the rules overboard. If rule is so construed, it may not stand the test of Article 14 of the Constitution. The proviso to Rule 13 can come into play in the matter of fixation of seniority between candidates who have successfully cleared the examination and candidate who cleared the examination after availing the benefit of relaxation. We are therefore of the opinion that tribunal committed no error in understanding the purport to Rule 14. The tribunal's order in review is assailed on the ground that it has no justification to reverse its earlier order, by which it has held that the challenge was time barred. The tribunal exercised the review jurisdiction as it had held to notice the correct provision and had therefore applied the wrong provision in declaring the proceeding time barred. The tribunal rightly point out that since the cause of action had arisen prior to establishment of the tribunal, the proceeding stood governed by section 21(2)(a) and not section 21(1)(a) of the Administrative Tribunal Act 1985, which it had wrongly invoked. We are therefore see no merit in this challenge. Now, even the tribunal came to conclusion that Rule 14 did not permit regularization made under the impugned order of January 3, 1985, February 14, 1985. It have regard to the long service put in by the employees named in the said two orders, and on compassionate consideration has supported the regularization under Article 162 of the Constitution. It has modeled the relief on such consideration. Since the part of the order has not been assailed, and since the appellant cannot be forced by appealing, we cannot interfere with that part of the order. It will therefore be worked out as directed by the tribunal, but we may clearly state that it will not have the effort to disturbing the seniority of the regular appointees who will rank senior to the irregular appointees. We may also clarify that any benefit derived by the irregular appointees under any interim order contrary to the relief modeled by the tribunal shall be adjusted and brought in tune with the said relief. The benefit of this relief, to the extent relevant, will be given to irregular appointees covered under both the impugned order of January 3, 1985 and February 14, 1985.
But in this case,
My
the
lord.
judgment which you are reading, the irregularity was found because they were not possessing qualification.
My lord.
They were not having qualification. So therefore, the court went on to saying that they were having no qualification. So therefore, they were irregularly appointed. But here is a case where it is not in that way irregular, in the sense that at the time when the appointment was to be done, this is the procedure.
Yes.
From the employment exchange, the names were sought for, and this can't be said to be irregular.
This was not done in accordance with the rule, my lord.
In true sense, it is not can't be said to be irregular appointment. That is the reason even in the judgment, in the last paragraph, it says that if possible, the relief should be molded in such a manner that these people should be protected. That also it says at the end.
My lord.
Why can't we relief be molded?
No, now the
Because
petitioner...
particularly for the reason that now it is not affecting anyone. It is a matter of only pension.
Yes.
The other people are not getting affected.
No.
So because of that, why can't the relief be molded?
My lord, the petitioner seeking that he should be placed above than the regular.
Those things are now gone. The real effect is today, he'll get the benefit of pension.
Except pension, there is
Nothing
nothing
is-
to be remained.
So therefore, even Supreme Court says that you can mold the relief in such a manner that the irregular, even if it is an irregular appointment, if some relief could be given, it must be given. If you would have been in service, we can understand that the cost of others' benefit is being given. Now nobody is there, only for pensioner benefit. That's the distinction.
No, submitted order. Further, your lordship, in this Supreme Court's order, we have also cited the same order, your lordship. In my written address, I also cited order. The paragraph 11 itself states that since the long service of the petitioner has to be considered for sympathy consideration, also, your lordship, this Supreme Court judgment, your lordship, the facts are very distinguished. The facts are there, your lordship. Kindly see Rule 13 of the women's rules, your lordship. Hold on.
Writ petition has been filed by the petitioner Jamin Mohan Mahanti, challenging the order dated 17/7/2014 passed by the Odisha Administrative Tribunal, Cuttack Bench in OA number 805 of 2009. In dismissing the original application, the original application was filed. Where is the copy of the original application?
The copy is not only the order.
What was the prayer in the way?
Page 19 or prayer is written, Your Lordship. Page 19, annexure 6, prayer is written in the order itself. To quash the order dated 24/3/2009 under annexure 4.
The original application was filed by the petitioner to quash the order dated 24/3/2009. Where is that order, particular order?
Lordship, annexure 5, page 16.
Passed by the chairman in charge of Arbitration Tribunal, Odisha, wherein the petitioner was reverted to the post of junior assistant and was relieved from the tribunal due to his reversion with a further prayer to the opposite party to allow him to continue in the post of section officer level 2 of the Arbitration Tribunal, Orissa, Bhubaneswar. The case of the petitioner in short is that the Arbitration Tribunal was created under the Irrigation and Power Department of Government of Odisha without giving any definite status, and the office was functioning under the Irrigation and Power Department. In 1978, one post of LD assistant and other posts were created. And on 8/1/1980, the District Employment Exchange Office was asked to sponsor the names of the suitable candidates for the post of LD assistant. On 24/1/1980, the Employment Exchange sponsored names of 17 candidates, including the petitioner. On 19/1/1980, the chairman Arbitration Tribunal was declared as the head of the department with effect from that date. And on 4/2/1980, the petitioner was selected and appointed for the single post of lower division assistant on the basis of written test and interview. And the petitioner joined in the said post on 29/2/1980. The opposite party number 3, PC Kanungo, was appointed about 4 years thereafter, that is on 25/4/1984.
As per OMS rule.
In the same post.
In the same.
As per OMS rule. As per OMS rule.
As per OMS rule. The chairman of the arbitration tribunal, by letter dated 18/3/1985, requested the FACOM deputy secretary to the government, INP department, to regularize the service of the petitioner with the OMS rules by virtue of the provision of Rule 14 of the OMS rules. The FACOM deputy secretary to government, INP department, in reference to the aforesaid letter dated 18/3/1985, regularized the service of the petitioner by order dated 28/6/1985 from the date of initial joining in the public interest by virtue of relaxation provision of Rule 14 of the OMS Rules 1975. After relaxation and regularization, the petitioner was promoted as a senior assistant on 11/7/1985. At that point of time, the opposite party number 3, PC Kanungo, did not raise any objection to the promotion of the petitioner as senior assistant. When the gradation list, provisional gradation list was prepared and it was circulated in the rank of senior assistant, inviting objection of any on 28/10/1995, the petitioner's name found place at serial number 1, and the name of the opposite party number 3 found place at serial number 2. By that time, the petitioner had completed 10 years of service as senior assistant. At that stage, also no objection was submitted by the opposite party number 3. And therefore, the said gradation list became final by order dated 19/12/1995. The petitioner completed the accounts training, cleared the department test, and was eligible for consideration for promotion to the next higher rank. And the DPC also found the petitioner suitable and recommended the promotion, and the petitioner was promoted to the rank of section officer level 2 on 1/1/1996 and continued in the said post till the impugned order dated 14/3/2009 was passed. It seems that the opposite party number 3 submitted a representation for fixation of the seniority over the petitioner after a long delay of 13 years of finalization of the gradation list and 23 years of delay of regularization of the service of the petitioner. So also, after 13 years of promotion of the petitioner to the rank of SO level 2. The FACOM Deputy Secretary to the Government INP Department directed the Chairman Arbitration Tribunal to revise the gradation list dated 19/12/1995 and fix the seniority of the opposite party number 3 over the petitioner after a long delay of 13 years of finalization of gradation list. In accordance to the order of the FACOM Deputy Secretary to the Government I&P Department dated 17/3/2009, the Chairman Arbitration Tribunal on 24/3/2009 revised the final gradation list dated 19/12/1995 and placed the opposite party number 3 at serial number 1 and placed the petitioner at serial number 4 by order dated 24/3/2009. Not only the petitioner in the said order was reverted from the post of section officer to junior assistant, but also since there was no other sanction post of junior assistant, the petitioner was relieved from his service after serving for more than 29 years. And the petitioner remained out of service and without pay till he attained the age of superannuation on 30/3/2013. Stop. When the petitioner challenged the order before the order dated 24/3/2009 before the London Orissa Administrative Tribunal, Patak Bench in OA number 805C of 2009, the London Tribunal rejected the original application It is the contention of the Land Council for the petitioner that the London Tribunal, prior to the passing of the impugned order, passed the interim order on dated 30/3/2009, wherein the London Tribunal stayed the impugned order of reversion dated 24/3/2009, if already not given effect to. However, even though the petitioner was reverted to the post of LD assistant, but due to filling of the said post from the person recruited through the OMS cadre, no post was left vacant and the petitioner remained out of job. Though the petitioner, in pursuance of the order dated 30/3/2009, passed by the London Tribunal, submitted a joining report to the Chairman Arbitration Tribunal along with the certified copy of the order, but the Chairman rejected the joining report. and the petitioner remained out of job, without engagement, without any salary. And accordingly, the Learned Tribunal, as per the order dated 23/2/2012, directed the opposite parties, number 1 and 2, to adjust the petitioner against the vacant post of the LD assistant for drawal of his duty pay till the final disposal of the OA, without prejudice to the petitioner's claim for continuance as SO within a period of 15 days. After 1 year of the passing of the such order by the Land Tribunal, the government, by later dated 7/2/2013, asked the petitioner to submit the joining report to the Chairman Arbitration Tribunal for the post of LD assistant, and accordingly, on dated 14/2/2013, the Chairman Arbitration Tribunal directed the petitioner to submit the joining report, and the petitioner submitted his joining report on 18/2/2013 and requested for sanction of the UL till 30/9/2013 due to ill health, and the petitioner retired on attaining the age of superannuation on 33/2013. The contention of the Land Council for the petitioner is that when the name of the petitioner was sponsored by the Employment Exchange along with other candidates.
Other
And-
16 candidates.
Other?
16 candidates.
16 candidates. And at that point of time, the same was the procedure followed for appointment to the lower division assistant, to the post of lower division assistant. And the written test and interview was held and the petitioner was selected. No fault can be found in the process of appointment of the petitioner. And accordingly, the petitioner joined the post of the LD assistant rightly. And the opposite party number 3 came into picture about 4 years thereafter. And thus the petitioner was senior to the opposite party number 3 in all respect. The petitioner's service was regularized from the date of initial joining in the public interest by virtue of the relaxation provision under Rule 14 of the OMS Rules 1975. And thereafter, he was also promoted to the senior assistant on 11/7/1985. And thereafter, the gradation list was prepared, and at the time of preparation of the gradation list also, the opposite party number 3 never raised any objection, and thus at a belated stage, considering his representation for fixation of seniority, which was about 13 years after the finalization of the gradation list, the petitioner's seniority should not have been disturbed, and ultimately he should not have been reverted to a lower post, and since no such post was available, he was relieved from his service. The Land Council for the petitioner submitted that the Lenin Tribunal was not justified in passing the impugned order, and it is liable to be set aside since the petitioner has already retired from service and only he has to get the pensionary benefits. The impugned order should be set aside and the petitioner may be given the necessary reliefs. The Lenin State, Mr. Naik, Lenin Additional Government Advocate, placed reliance in the case of State of Orissa versus Shukanti Mahapatro and others reported in so and so, wherein considering Rule 14 of the
OMS Rule 1975.
Odisha Ministerial Service Rules 1975, it has been held in the backdrop of the said case that which are the paragraphs you are placing?
My lord, I first placed paragraph 3.
It has been held
whether the appointment of
the issue was raised as follows. Quote paragraph number 3, Jodaki underline H. The
paragraph 3. Paragraph 9.
The Honorable Supreme Court answered the issue in paragraph 9 as follows. Quote the entire paragraph number 9.
9 to 11.
9, 10, and 11. On perusal of the factual scenario in the said case, it appears that it is completely different than the case in hand. Distinctive feature. Therefore, we are of the view that the ratio laid down in the said case has got no application to the case in hand. We are of the view that the Lenin Tribunal has not properly considered the points raised by the petitioner, and accordingly the impugned order is liable to be set aside. However, taking into account the present scenario, the prayer is to be molded as follows. All right.
One submission, my lord. In this case, the appointment should have been made as per by the Board of Revenue. As per the OMS Rule 1975, the recruitment should have been.
But the recruitment process is already initiated before that. That's the distinction.
Yes,
We'll
my
do
submission that
We'll do
Board of Revenue.
make a mention. Criminal appeal 388 of 19. This was listed last on 25th of August. The Lordships adjourned it to 8th of September, calling for the conduct of the appellant while on bail. Thereafter, it is not being listed. Another criminal appeal, my lords, also 347 of 2000. This was listed on 28th of July, adjourned to 11th of August, and still it's not coming.
Pardon, mention, madam. Offense is under section 376G. Petitioners are languishing in jail custody more than 13 years. Another matter, your lordship directed to offense is under section 302. Your lordship directed to list this matter after ensuing after puja vacation.
Bail pay?
For bail.
Pardon to mention, one CRLA 109 of 2019 matter. In this case, the present appellant is custody matter more than 10 years, and the court person have already been released on bail.
My lord, the petitioner is in custody for about 12 years, and another is 9 years.
Let's the 302 matter, my lord, the appellant is in custody since 5 years for bail, my lord.
Pardon to make a mention, your lordship, sir, for extension of time for surrender. I has been filed.
Why extension?
Not sure.
You must have granted interim bail for a particular period. So why extension?
Not sure, sir. I'll take instructions from my senior.
People bail. I may plan to mention lordships. Item 62, your lordships. Appellant's wife has been died on 24, lordships. They have filed a miscase today for interim bail, your lordships.
Has it been numbered?
It has been numbered 2911. 2911 of 2025.
Copy so that
I have already solved the copy, your lordships. Today.
You are giving the copy.
I have already solved the copy. Okay. Copy is ready. I am solving your lordship.
It will be taken up on day after tomorrow. Just obtain instruction about the death of the appellant's wife who died today.
Give another copy then.
Yes, sir. I am solving your lordship.
That is item number
62, your lordships.
62.
CRLA 998 of 2045.
Achha. That IA has not been listed.
Yeah, what that IA has not been listed.
What is the IA number? Tell us.
2911.
2911
of 2025.
25.
2911
on the ground of the death of the wife.
Yes, Lord.
Click on the item number 60. Mr. Das submits that he has filed an interim application for bail today.
Yes, yes.
Which has been numbered as the number 2911 of 2025 for interim bail on the grounds that the wife of the petitioner has died. And a copy of the interim application has been solved on the Land Council for the state. The Land Council for the state shall obtain instruction, the interim application. You give it over.
Yes,
to us. We put up this matter on 29th of October 2025.
I beg pardon, my lord. Item 61. Last occasion, lordship called for the report, the illness of his wife. That has come. Maybe taken up as the last case, man. He was seriously ill. That's why.
Okay.
Weekly list item number 1.
One matter that not giving for yes,
Yeah. Mr. Saurabh, you appear, you file wakalatnama for this man.
You fill up the wakalatnama, file it.
You are having practice of 10 years. Mr. A. Saurabh and counsel is engaged as the amicus curiae for the appellant. The land counsel for the state has obtained the wakalatnama from the appellant. Stop. Let the prisoner's petition, judgment copy, and the deposition copies of the witnesses and the FIR, final form, and the exhibits be handed over, be given to Mr. Saurabh in his pen drive. Aji nahi jantu. And you soft copy nahi jantu. You file a bail application by tomorrow. We are listing it day after day. He is in custody for 14, more than 14 years. And also the orders orders dated order dated 13/10/2025. Last order to complete. Is custody 18/4/2011. So 14.5 years. Yes. Day after tomorrow. Indicating the name of Mr. A. Saurabh in the cause list. The name of Mr. Ramakant Mahapatra shall not be reflected in the cause list henceforth. Yes, next.
Item 2.
Convicted for life for the offense section 302.
Just a minute. Order number so standing around. IN number one for bail. Report received from shown state instruction.
Custody jail, conduct and criminal.
या ना कौन
साधन सिंह कर रहा है
ये कोडिया लोको
करंजल
अच्छा local local as well as PSK found nothing adverse against him. He is involved in one case. अच्छा 498-304 की penalty. 14 years. IN number 1731 of 2025. There is an application for bail. The land counsel for the petitioner submits that the petitioner was taken into judicial custody on
29/4/2011.
30/4/2011. And his application for bail was rejected on 29/2019. So also on 4/12/2020. ଗୋଟେ ଇଣ୍ଟ୍ରିମ୍ ବିଲ୍ ଦିଆ ହେଇଥିଲା ଆଭେଲ କରିଥିଲେ
ମାସେ ପାଇଁ
ଯାଇଥିଲେ
yes ma'am କରୋନା ପିରିୟଡରେ ମାସେ ପାଇଁ
ଆଚ୍ଛା ଏଠି ଲେଖା ହେଇଛି the petitioner was granted interim bail for a period of
3/3/21
30 days. Yes, right order dated 3/3/2021. and after availing the same, he surrendered at right time. Land Council submits that the petitioner is in judicial custody for more than 14 years. And since there is no chance of his absconding and he is a local man, the bail application may be favorably considered. As per the order dated 17/9/2025, the London Council for the State has produced the custody certificate of the petitioner from Superintendent Biju Patnaik Open Air Ashram Jamujari, which shows that as on 25/10/2025, the petitioner has remained in custody for 14 years, 4 months and 26 days. He has also obtained the conduct certificate of the petitioner from the jail superintendent to show that during the incarceration period in the ashram, his attitude, behavior, conduct, and character are found satisfactory. Land Council for the State has also obtained written instruction from officer in charge of Thakurmunda Police Station, which shows that there is no other criminal antecedent against the petitioner. The reports produced by the Land Council for the State have taken on record, considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, the conduct of the petitioner in complying with the terms and condition of the interim bail order of this court, and absence of any chance of early hearing, we are inclined to release the petitioner on bail. Order copy to be communicated to the superintendent Sahoo and also to the London trial court by the registered judicial.
Item 3.
Years 2007. Absconding.
He was granted bail.
No. Open the doors and. Well, once this is brought to our notice, what more than. I feel more than 50 cases. Due to the advertising, we saw it with the make a book of them. And that is what you also so also you can someone freely would shop to construct for the if you warrant. No, steps also steps taken to a warrant for Nisha hates you.
Warrant has been issued.
चंदेगा पुलिस स्टेशन दे खाली कौन एफआईआर टा दे दी रहिले ना ताकू कोठू किछि
किछि प्रोसेस ही ना कोन
स्टेप नउचंदी लोकड़ा तो होची एठिकार ना बरगढ़ जिल्ला रो you obtain the steps taken for his arrest है the Land Council for the state has produced the written instruction received from Superintendent Biju Patnaik, Open Air Ashram Jamujari, which shows that the appellant absconded from the lawful custody of the ashram on 19/6/2018. For which a case was instituted in Chandaka police station against the appellant under section 224 of the IPC on 21/6/2018. However, the appellant is yet to be arrested. The Land Council for the state shall obtain instruction as to what steps have been taken for the apprehension of the absconding appellant. And also a report has to be called for from the Superintendent Biju Patnaik Open Air Ashram Jamujari as to how many persons who were lost in Biju Patnaik Open Air Ashram Jamujari have absconded till date, giving their names and case numbers.
What are the status of? What are the status?
And about the status of those cases and what steps have been taken by the state to prevent such absconding. Put up this matter on 10th of November 2025. Free copy of the order be handed over to the Land Council for the state.
This must be the affair of the broken thing.
See, Mr. More than 40, as we have informed, they have absconded.
Those conduct found would be in jail, they were transferred to you.
No, we know that they must have remained in the custody for 6 years. That was intimated to us. And once they must have gone on this parole, and they have returned within time, only such cases.
And those who have a good conduct, those who have good conduct.
Only those persons are taken there. But in spite of that, more than, as we are told, more than 40 cases, the persons are absconding. And all those are live convicts.
One is the report that is living in Jharkhand, but not in.
But this is regarding one jail, one open jail. We don't know what is the story in the other open jail.
There is no proper, so strict principle is maintained here.
No,
Taking advantage.
the
Boundary.
what we know that it was spread around 110 acres, and there is no boundary as such. The wall like the other jails, so they are moving freely. And but there are guards, all the security personnel are there, and like other jail, when they are taken into they are at about 6 o'clock they were taken inside, but here the deviation is that they are allowed to remain till 9 o'clock outside, and then after that they used to take, but 40 cases have been live convicts are absconding. So let the report come.
Item 4. Or I pray for 1 week time. Like by next week, I will file an application for bail. Actually, this matter was left out. I have filed in other cases, but I was under presumption that this has been re-engaged by the accused from the jail. So I left. I beg apology for that. I will file by this week.
Have you seen what the custody period?
Yes, since 2014 he is in custody. Just today only I got the paperwork from the section. So
either you prepare on merit or file the bail application, because this is a jail criminal appeal of the year 2018. And the matter was
He's in custody since 14.
14. He has not
File an application.
He has not filed any application. We are keeping it day after tomorrow.
I will file.
Mrs. Sunita Biswal and counsel for the appellant submits that she intends to file an interim application for bail by tomorrow, and the matter may be taken up day after tomorrow. Place this matter on 29th of October 2025. You obtained that in the meantime, in which jail he is now, that custody certificate and the jail conduct, and also the criminal antecedent.
Item 5.
Same.
No, today I have also filed IA and number also.
What is the number?
Yes, sir. Today morning. 15, more than 15 years in custody.
14/10/2010.
14/10/2010. And this is the second time we listed before lordship.
And we have verified the order sheet. He was never released on bail. Always he was produced in court from jail, and
yes, sir.
Whether your bail application was earlier rejected?
No, never filed.
There is no direct evidence also.
No.
That's what you written. Paragraph 7 you have written.
This IA number, it has already been filed.
Yes, sir.
349.
349.
Tami number ita maro application. Mogi Ufram Shea Kuji. You are passing the order, but you get the and have a You are having a
Yes,
copy
sir,
of this?
copy.
Look on this is an application for bail. The land counsel for the petitioner submits that the petitioner was taken into judicial custody on 14/10/2010, and he was never released on bail either during trial or during pendency of this appeal, and as such, he has remained in custody for more than 15 years. He further submits that it's a case based on circumstantial evidence.
There is no eyewitness.
And there is no likelihood of the appeal being taken up for hearing. Therefore, the bail application may be favorably conditioned. Local
Yes, sir. Saroda.
and is a local man.
Bhanjanagar.
Land counsel for the state opposing prayer for bail, considering the submission made by the land counsel for the respective parties. Period of detention of the petitioner in judicial custody for more than 15 years, absence of any chance of early hearing. We are inclined to release the petitioner on bail. But a communicate how superintendent ko, how the trial court will communicate how ye original ye the petition does and la pore goal bade. No, yes, next.
Item 6.
Already I have filed the IR for bail, my lord. The IR number is 350.
Copy again.
Hello, the original copy I have online file for this. The original copy da. The custody from 20th August 2017. Petitioner is a lady. She is convicted on the circumstances, basing on the circumstances evidence, my lord.
Day after tomorrow, as you land counsel for the petitioner submits reference submit that he has filed an interim application for bail. Aji file karjandi.
My lord.
Today, which has been numbered as IR number
IR number 350. 350.
350 of 2025, and copy of the application has already been served on the land counsel for the state. Put up this matter on 29th of October 2025. With IU number so and so.
Item 7.
Tax C received from the additional passengers in terms of the order of the class division. Hearing bill, after appealing bill, the appellant did not surrender for which enroll has been issued.
Is not surrendered.
Not surrendered.
Enroll
has not yet been executed.
So,
we have also intimated the IAC to report that.
IAC କିଛି କରିବନି 2014 ନା ସେ ଗାଁରେ ବୁଲୁଥିବ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ କୁ କୁହନ୍ତୁ ସେ steps କଣ ନେଇଛି period the report of the when first additional session judge comes special judge under NDPS Act Kurda. Which shows that the appellant was released on interim bail on 8/8/2014 as per the order of this court dated 3/3/2014 passed in miscase number 10 of 2014. And he was supposed to surrender on 6/10/2014. But he did not surrender on the date fixed for which non-bailable warrant of arrest has been issued against the appellant, and till date neither the appellant has surrendered nor the NBW has been issued. NBW issued against the appellant has been executed by the IAC Banki Police Station. Stop. Let both IAC Banki Police Station as well as Superintendent of Police Khurda file affidavit regarding as to what steps have been taken for execution of non-bailable warrant of arrest issued by the London Trial Court for the arrest of the appellant. This matter on 10th of November 2025. A free copy of the order be handed over to the Land Council for the state. Yes.
Item 8.
So if I may please your lordships, my lord.
Custody certificate.
କେତେ ଆସିଲା?
7 ବର୍ଷ 13
7 ବର୍ଷ 13 ଦିନ। କେବେକାର ସେଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ?
Custody since 13/5/2025.
2025 ହଁ 7 ବର୍ଷ 13 ଦିନ ଠିକ। So whether your bail application was earlier rejected?
Indeed not, your lordship.
Not. Achha. What is the offense here?
My lord, 302.
Yeah. Committing murder of Krishna Chandra Sahu.
Indeed, your lordship.
Earlier he was convicted due to death of Mr. Pillai's father. Now the mother.
Mother.
No brother.
Krishna Chandra Sahu is the father, your lordship. Is the
Earlier also
appel-
you accused.
No, indeed not, your lordship. This is the appellant presently is the son of the deceased.
Ah, sir. Here is son. Father killed his father for not killing.
Please come to that paragraph 2 of the judgment.
Your lordship.
Please read it out.
The prosecution case, as it reveals from the FIR, that on 12/5/2018, in the morning at 10 a.m., while the father of the informant taking his meal at his veranda, his younger brother, accused, asked to his father to give some money, but his father denied to give money, for which his younger brother, Niranjan Sahu, became angry and threatened to kill his father. He took an axe and gave axe blow on the neck and shoulder of the father by the said axe, as a result of which his father sustained severe bleeding injury on his neck, became senseless and fell down on the ground. Seeing this, the informant and his mother, along with others, took the father to DHH Angul for his treatment. As the health condition of this father is serious, he was referred to SCB Medical College, Cuttack, in unconscious stage. On the basis of the said information, the Jharkhand PS case number dated this is registered under sections this of IPC. The IIC directed the ASI to take up the investigation in the case. During investigation, the IO examined the complainant and other witnesses, visited the spot and prepared the spot map. On 13/5/2018, he arrested the accused and recorded his confessional statement under section 27 of the Indian Evidence Act. In consequence of the statement of the accused, the IO seized the weapon of offense. During his investigation on 17/5/2018, he ascertained that the injured Krishna Chandra Sahu died in consequence of the injury caused by the accused. Then he handed over the charge of the investigation.
Witnesses are there.
One eyewitness.
PW4.
PW5.
Sister.
Your lordship.
The daughter of the deceased.
Sole eyewitness, no?
Indeed, your lordship.
PW5. Are you having the deposition?
Indeed, your lordship.
Please read it out.
PW4 also.
PW4 is the informant.
He has also seen it.
My lord, but she turns hostile and says that I have not seen the occurrence. I came to know late.
In the cross-examination para 4. But I heard it from my sister Sasmita.
Yes.
Sasmita is PW5.
Yes, your lordship.
What is she has stated?
My lord, paragraph 2, on 12/5 in the morning, my father had gone to plough the agricultural field and returned at about 10 a.m. At that time, my elder brother, Kaliya Sahu, and my mother had gone to another field to dig onion. When my father returned, I served him food and he took his meal in our veranda. At that time, my another brother, Niranjan Sahu, was present in our veranda and begged some money for his personal expenses to my father. But my father denied to give him the money as he is not working anything. That is why my brother, Niranjan Sahu, being angered, brought an axe tangia from my veranda and hewed on the backside, neck, shoulder, and thigh of my father again and again. At that time, my father raised by saying, Morigali, Morigali, Niranjan Mate Maridala. On seeing this incident, I raised Halla, for which our neighbor Basanti Pradhan and Daitari Pradhan came to the spot. On seeing them, my brother Niranjan fled away
to the backside of our house by taking the Sedax. My father sustained heavy bleeding injuries and became senseless. So I immediately proceeded.
No cross-examination.
No cross-examination, my lord.
You obtain instruction about that girl, because once he goes there, he will first attack that girl, his own sister. Because she is an eyewitness on the basis of whose statement she has been sentenced to
He
life.
was 18 years when this statement was recorded.
2019, and at that time she was unmarried. What is your status? We do not know. Look onto and she was reading close to second year arts at that point of time. IN number 127 of 2019 is an application for bail. During course of argument, Mr. A. Saurabh and counsel for the appellant submitted that PW5 Susmita Sahu is the eyewitness to the occurrence, who is also the sister of the appellant and daughter of the deceased. Stop. The land council for the state seeks some time to obtain instruction regarding the status of PW5 put up this matter on 10th of November 2025. The land council for the state shall also collect the criminal antecedent, if any, against the appellant, so also his jail conduct. Hello?
Grateful.
Yes, next.
Item 9.
My lord. Sir, for bed, item number 225 2023. Offense committed in 2 of IPC.
You got the custody certificate?
My lord, occurrence date.
Wait, madam, wait. Give it. No, कितने हो चीड़ है?
4 years, 3 months.
1, 4, 7, 5.
4 years, 3 months. My lord, no eyewitness.
Ask for out your room.
My lord, here in this abundance evidence.
State has produced the custody certificate, also the criminal antecedents of the petitioner, which are taken on record, put of this matter in January 2026. Yeah.
Item 10.
In this case, my lord, 2 cases is there, my lord. I am appealing for the first case, my lord. This year, 55 of 2025.
Lordship, on behalf of Mr. S. Palley, I am appearing for the accused in the second case.
Second appeal.
Wait. What are the materials against you?
Eyewitness is there, my lord.
Yes.
Eyewitness is there, my lord.
Eyewitness there.
Yes, my lord. Double 13 and 17, my lord. Double 13 is hostile, my lord.
Just a minute. 15 and 17.
Yes, my lord.
13 has not supported the person.
Yes, my lord. Only double 17, my lord.
17? 17 has supported.
Yes, my lord.
Please read it out.
I now the informant, I now the deceased, I now the accused person standing in the dock. The occurrence
It's not now, it's no.
Yes,
I
ma'am.
know the.
Yes, ma'am. The occurrence took place prior to 2 years back, one day at about 11 p.m. near the hockey field of Patwagara. On the relevant date, I, along with Amrit Lakra, had been to the house of accused John Kispat as his guest, and then we went to the house of Elijah Village Patwagar, being called by accused John, the present person, to attend the ring ceremony at about 11 a.m. We reached the house of Elias and we took tiffin there. At evening time, we took our lunch and we also danced as there was a dance program for the said occasion. The said dance program continued till 10 to 11 p.m. on that night. After the dance program, I, along with accused Johan, Vishal, Amrit, accused Roshan, and deceased were going toward the house of accused Johan. Accused Johan uprooted one of the wooden pole of the goal post of hockey field. The deceased and accused Roshan were moving ahead me, Johan and Amrit. Then accused Johan dealt a blow to deceased Vinod by the said wooden pole. When the deceased was running away from the spot, accused Roshan caught hold of him and pressed him on the ground. Then the accused Johan dealt two to three blows by means of a stone on the head of the deceased. At the spot, the deceased succumbed to the injuries. Then I, along with accused Johan, Amrit, went to the house of accused Johan and other two went to their respective houses. After one day staying at the house of accused Johan, I returned to my house. I was examined by the police. In cross-examination, I have...
Last one blow was given by a wooden pole.
Yes, my lord.
On the then
Stone, my lord.
the next blow is stone. Acha. And all those are given by John. So far as the allegation is Roshan is concerned, he caught hold of him.
Yes, my lord.
Okay.
The stone
What have
was
you brought
placed
out in the cross-examination?
Cross-examination, I have came to the court today along with my parents and elder father, Sati. It is not a fact that I had not stated before the police that while we were going towards the house of accused Johan, on the way, accused Johan uprooted one of the wooden pole of the goal post of hockey field, and that I had not stated about existence of a hockey field. 3 to 4 days after the occurrence, I was examined by the police. Before disclosing the matter to the police, when I was examined by him, I had not stated about it to any other person. I had accompanied my father to the said function of Elias. As the court feel that the witness did not understand the question again being asked, the witness stated that he had been to the house of Elias along with his friends and accused persons. I had not gone to the spot again when the police arrived near the dead body. Amrit and Vishal were present. with me when I was examined by the police, but police examined one by one, not in presence of others. The witness explained that I, along with Amrit and Vishal, were in one room and police called us one by one and asked about the incident outside the said room. While I was reading in the school, in case of dispute and fight among the friends, I used to convey the same to my teacher. I never disposed assault on me to my parents unless the assault is severe. Police at first came to my house and then took me to the police station, and the two other friends, namely Amrit and Vishal, were also called by the police to the police station. I was examined at the police station. It is not a fact that I had stated before the police that I had no knowledge about the incident.
This you have proved to the IO.
My lord,
ତାକୁ ପଚରାଗଲା ଯେ ଆପଣ ପୋଲିସ ପାଖରେ କହିଥିଲେ ଯେ ଆପଣଙ୍କର ଏଇ ଯୋଉ ଘଟଣା ସମ୍ପର୍କରେ କିଛି ଜ୍ଞାନ ନାହିଁ। এই ଜିନିଷ ପୋଲିସ ଜରିଆରେ ପ୍ରମାଣ କରିଛନ୍ତି who is the IO?
yeah, P19, my lord.
PW17 ନ ତ କିଛି ଗୋଟିଏ IO ସିଙ୍ଗଲ IO ନା ଆଉ କିଏ?
Single IO, my lord, P19.
No. There is another IO, I think. PW19 actually. Oh, 1959. How you put this question to the that witness? किसी तमें पुलिस पकड़े कोई जो तमें जानी ना बोली तो ता ना कौन 17 नंबर ताकिरो?
Manjit means.
हाँ?
Manjit means.
Correct. I used to go to Kottagam. He along with that was only left from Mandir had been
Singro. सत्ताईस सोमवार दिन 11टा बड़े सब भोजी खाई गल सब देखा से गल बाहर सामने घर बाहर आगे स्वांशु पछे पछे फुटबल फिल्ड पाखर एक बाड़ी भांगी बिनु देखा को जीवन मारदेव बोली कहला बिनु देखा भयर दौड़ा पर रेशन बाला ताकि धरी एक शाल गछ तले पटकी देला तापरे जनठी कटा एक बड़ पत्थर उठे बिनु मुंड को चिंता करा किसी स्वांश और कही नाई कौन कहला how you are making that irrelevant thing. This man has assaulted John, and this Rosen has a little तार period of detention केते रोशन
नहीं
Despite several applications, no one is coming forward to swear the affidavit.
There is no application on here.
No.
No, we just want to know that what is that application. Period of detention. City of Rosen Balauchi 34/2021 to 4 years 5 years.
You are not entitled, he is not move application.
IA number 4159 of 2024. This is an application for bail put up in the matter in January 2026. Baki jo JCRL numbers want so the Land Council for the petitioner submits that he'll obtain instruction in the matter and file an application for bail plus ethical charging. Yes. You see, it's not necessary that somebody from the family should come. Whatever they are on record, you can also prepare a bail application and ask your clerk to file an affidavit. Because period of detention, there is no dispute because that is on record. About that allegation against him is these are all matter of record. So something which is to be based on personal knowledge matter is different. Otherwise, the bail application can be filed with the affidavit of the advocate's clerk. For that, not relatives are not necessary always.
Your Lordship, we will file the application for the making.
File. Yes, next.
Item 11.
Lordship, in this case, Lordship, the last occasion, adjourn this matter to today, Lordship. That is, in this case, I am filed a bail application and affidavit of the father of the appellant, Lordship. He is suffering from psychosis, NOS, Lordship. Last occasion, report also came after verifying the adjourn today, Lordship.
What is the age of the father?
Father is the
77.
Yes, Lordship.
He will take care of the son who is
That
psyche. Once daughter of son, 75 years. Still he is under treatment.
His condition is that report was published 2/10/2024, thereafter also.
Report as the jail superintendent report she was suffering from Swansu and the proper medical.
He could not able to handle the part because of full day.
Huh?
5/25 report was published.
Report ଅଛି ତ ସେଇଥିପାଇଁ ଇଏ ବାହାରୁ ଗଲେ କଣ ବର୍ତ୍ତମାନ ଗୋଟେ ଷ୍ଟ୍ରିମଲାଇନ୍ ହେଇକି ଚାଲିଛି ନା ତା ବାପାଟା ତାକୁ ଯଦି ମନେକର ସେ ଟାଇପର ପେସେଣ୍ଟଙ୍କର ମେଡିସିନ ବି ଯଦି ଗୋଟେ କୌଣସି କାରଣରୁ ଡିସକଣ୍ଟିନ୍ୟୁ ହେଲା ସେ aggressive ହେଇଯିବେ.
And there is a danger to the life of the father.
That is also.
He is a psycho patient. He can do anything to the old father.
His father
There is no one in the family.
Let's say I am contact to his father, but father is requested me he can handle it.
Oh, madam, that's very easy to say. Yeah.
His father repeatedly requested me.
In the jail, when such type of patients are there, in many jails we have one.
Father is requested me.
They even do not give those patients the medicine to their hands. They, at the appropriate time, they used to call that man and they used to administer it in their own hand. They don't even give that because sometimes they used to keep it and throw it. So, and sometimes, so
Father,
that is the reason.
father might, out of love and affection, father might be telling that, but he may not be realizing how difficult.
His religion well, I will take care, Lordship. He is repeatedly.
Age just 77 years.
Recently, we have seen those patients, the type, because in the jail, the advantage is that the psychiatrist is coming and they are also the clinical psychologist. They are also coming and there's a different situation totally there. And they are monitoring, they are giving these medicines regularly. So that is how everything is normal. And once this man goes out of it and he discontinue the medicine, and
he will not be taken care of himself also.
Age is 77 years.
Kindly send interim bail, Lordship.
2-3 months, Lordship.
Because the report
His
is
condition is good.
the report of the jail superintendent is that he is under medication, and once he goes, then it will create problem because there is nobody else. A little discount because the disease is such that it may create problem. So that
Once he goes out, he may discontinue the medicine. And who will take care of him? That's the problem.
ତାଙ୍କୁ medicine ଦିଆହଉଛି ସେ ପଚାରୁଥିଲୁ ଆମେ ସେ recently had been to that ଝାରପଡା jail the medicine ଗୁଡା କଣ କରନ୍ତି deliberately ତାଙ୍କୁ ଦେବେ ପାଟେ ସେ କଣ କରି ଜିଭ ତଳେ ରଖିଦେବେ ଜିଭ ତଳେ ରଖି ଖାଇବେନି ପାଣି ପିଇଦେବେ ତାପରେ ଫୋପାଡ଼ି ଦେବେ ତାକୁ ମେଣ୍ଟାଲ କାମ କରୁନି ନା ତେଣୁ ଏମାନେ ତାକୁ ପୁରା ତା ଇଏ କରିକିନି ଦିଅନ୍ତି ଦେଖନ୍ତି ଯେ ଢୋକିଲା ପରେ ତାପରେ ତାଙ୍କୁ ଇଏ କରନ୍ତି
No, last occasion I'm instruction to his jail superintendent, Abanti Singh. But say she said me that his behavior is good, Lordship. His behavior is
Because he is on medication.
No, report আসছে আমি এটা বলতে 10-4 আসছে 10-4 রিপোর্ট আসছে 10-4 আমি অর্ডার লিখছি ଆଉ ଗୋଟେ ରିସେଣ୍ଟ ରିପୋର୍ଟ ଗୁଡ଼ା ଆଣ ଦେଖନ୍ତୁ
Improve ହେଇଥାଇପାରେ
let the land council for the state obtain a fresh report regarding the health and mental condition of the appellant. To put this matter on 10th November 2025. Yeah.
But then,
last week also, and he was beginning to self and also showing self-love. And we see psychology out from the beginning of the
10th November, no. At the 10th.
10th. Yes.
Item 12.
May I please Lordship? Last time the foreign status of the mother-in-law and wife of the applicant was called.
Yes. Got any report?
So criminal antecedent, nothing adverse on that.
Whom he has killed, this man?
His son.
Son.
Oh. If I tell you.
Any eyewitness is the
PW8. That mother-in-law.
mother-in-law.
Suspecting that.
Motive is that on that day, he came to his father-in-law's house, didn't find his wife and daughter.
So the 5-year child is
There.
that's the reason the wife Jo already married somewhere else.
No.
She that is the report and she is opposing. Basically.
Report has come, the wife is married and this man will target first that mother-in-law, that because it is on his statement, her statement, she has been sentenced to that old lady.
70 years.
How many years, by the way, you are in custody?
Today completed 5 years.
5 years.
26/10/2025.
January.
Today is not
the Land Council for the Land Council for the state has produced the reports as per the order dated 13/10/2025. This month, January.
The police apprehended on 23/10 but arrested on 26/10.
January 26, yes. Actually.
Item 13.
Please, madam. The petitioner is languishing in custody more than 12 years. That the custody certificate as well as the conduct certificate is also there. Sorry, sir. Oh, sir. This is not my matter.
This is regarding interim pay. Yeah,
your matter. Please.
Mr. Punda was hijacking your matter.
Sorry.
In it, appellant filed the IN number 1467 of 2025 for interim bail. That is found that his eyes are disease in both eyes, seriously affected both, and always flowing water, tear. Operation is required. 3 months.
On the ground of ailment of the petitioner. District from during the period of interim bail. The FIR was lodged against one, so the said case charge sheet has been submitted. Then specific elements in paragraph 8, 9, 10 of the interim application. On 8, 9, 10 mentioned. Petitioner suffering from eye problem seriously affected sponsor. Unlucky. Report. His age is 70 years.
Yes, sir.
And he's suffering from old age related ailments. And particularly his eye needs operation. In which jail, ma'am, he is now?
Which jail?
Who jail achi na janna thi?
Barikota.
Barikota upon the order ta pass helani September ma shuru. Have you sent any intimation to the?
Yes.
So why he has not responded?
One of the
Get it by, we are taking up on 29th. Otherwise, you'll ask him to appear. The London Council for the State seeks for an adjournment till day after tomorrow to obtain instruction on the, as for order dated 23/5/2025. Put up this matter on 30/10/2025. Order ta pass ହେଇଛି ଆପଣଙ୍କର 23/5/2025 ରେ first time pass ହେଲା.
Same day
ଆସିଲା
also letter was issued. 12th by day after tomorrow.
On this boss 2025. Yes, next.
Item 14.
Yeah, please, Your Lordship, I'm appearing on behalf of Ms. Nanda. Lord, on the last occasion, State Council said that notice has been served on the informant if she wishes to oppose bail. Some time was granted for that reason. But this is the offenses under section 376.
Service ହେଇଯାଇଛି
Service ହେଇକି ଆପଣଙ୍କୁ ପୁରା
ନାଇଁ
କୁହାଯାଇଥିଲା।
ସେଟା ପଠେଇ ନାହାନ୍ତି photo.
It was served on that very day, my lord.
No, we have mentioned, ma'am, that it has been solved.
My lord.
What is the copy of the notice? We wanted that we are interested to engage any counsel on our own or from the counsel from the legal or so that is the purpose for we adjourn the matter. So
Have you written letter?
Yes.
When have you?
29/9 ଯାଇଛି ଆପଣଙ୍କୁ ଜଣାଇଦେବି ଉପରୋକ୍ତ ମକଦ୍ଦମା ଆସାମୀ ସରୋଜି ଏତେ ଏତେ ପାଇଥିବା ସଜା ବିରୁଦ୍ଧରେ ଅପିଲ କରିଛନ୍ତି ସିଆର ନମ୍ବର ଏତେ ତେଣୁ ଆପ୍ଲିକେଣ୍ଟ ନିଜେ ହାଜର ହେବେ କିମ୍ବା ଓକିଲଙ୍କ ଦ୍ୱାରା ଲିଖିତ ଅଭିଯୋଗ କିମ୍ବା ଯୁକ୍ତି ସ୍ଥାପନ କରିପାରିବେ ବୋଲି ଜଣାଇ ଦିଆଗଲା ଏ ସମ୍ବନ୍ଧରେ ଆପଣ ଚାହିଁଲେ ମାଗଣା ଆଇନ ସହାୟତା ମଧ୍ୟ ମାନବ ହାଇକୋର୍ଟ ଓକିଲ ଦ୍ୱାରା ପାଇପାରିବେ।
ସେଇ ଯୋଉ ଜିନିଷଟା
ସେଟା ଦେଇନାହାନ୍ତି we have also contacted to him.
ଆଣନ୍ତୁ day after tomorrow. Is this matter on 29/10/2024? Yes.
Item 15.
Yes, with the counsel for the C. Kasturi entered, appeared for the appellant on the last date. This is bail application.
19/24 that bail has not rejected on 19/12/24.
No, she has filed another bail application. So, by the way, how many years this man, Hiru Bag?
11 वर्ष 8 मास कस्टडी सिद्ध रिपोर्ट
15/12/2013 ରୁ ରହିଲାଣି। So eyewitness
dying declaration, but we don't have the deposition copy. As per the judgment, that the dying declaration there, 3% is died.
Acha. It's a case of triple murder.
Triple murder.
The learning counsel for the state has produced the custody certificate of the appellant, which is taken on record. None appears for the appellant. Put up this matter, urgent government.
Item 16.
Please, my lord, here the petitioner is languishing in jail custody for more than 12 years. And the custody certificate as well as the conduct certificate was called for and it is there.
How many times your bail application was earlier rejected?
Once it has been rejected in the year
23.
Yes. It was 12/1/2023.
12/1/2023 rejected.
Sir.
Anilati.
Fact Z also there.
Yes.
Fact Z.
custody certificate ଅଛି ଟି?
ଆଜ୍ଞା
ଜେଟ୍ ହଁ ଏଇଟା କେବେ କର? ଆଚ୍ଛା 18/5/25
12 ବର୍ଷ 2
12
ମାସ
ବର୍ଷ 2 ମାସ ତାମାନେ ଆଉ 5 ମାସ ଏକ୍ସଟ୍ରା ହେଇଗଲେ 12 ବର୍ଷ 7 ମାସ ହଉଛି। କଣ ଏଇଟା କି କେସ୍ ଏଟା?
એટલે double murder case of
ଆଚ୍ଛା
Schedule 7 and 11 of the eyewitnesses. Schedule 9 and 18 the doctor was the 9 and 18 doctors.
No, it's all right. I think. EW9.
X-ray having.
9 and 18 are doctor.
9, 18 ಎಲ್ಲ doctors.
PW 16 informant.
No, eyewitness.
Eyewitness is PW 7 and 11.
Conduct କଣ ଅଛି criminal antecedent?
That is there, sir.
Yes, what about the jail conduct and his criminal antecedent?
That is there, sir.
Who did?
In the report.
Okay, that is in the file. Earlier they have also given that too.
It was thought of.
Yes.
Criminal antecedent,
Conduct is Sanjay Khan.
Conduct.
Behavior
Jet
towards
one.
his fellow.
Jet 1.
Good. Till now, no offense recorded in the jail. In 2018, he is engaged in the jail saloon as a barber. Then after he is engaged as well as the guard and also selected a member of the Panchayat Council inside the prison.
Sir, this
Last 2 years.
vocational training program on plumbing and mobile repairing, this minor repairing work. Or the land council for the petition land council for the state. The land council for the petition submits that the petitioner was taken into judicial custody on
15 2014.
On 17/8/2014. He has never been released during trial and also during pendency appeal. And his bail application was earlier rejected by order dated 12/1/2023. The Land Council submits that since the custody certificate indicates that the petitioner is in judicial custody for more than 12 years, including the period of earned remission, and there is no criminal antecedent against him, and his jail conduct is also good. And there is no likelihood of the appeal being taken up for hearing in the near future. The bail application may be favorably considered. The Land Council for the state has produced the custody certificate and also the instruction relating to the criminal antecedent, which shows that there is no criminal antecedent. And so far as the report on the jail conduct is concerned, the Superintendent District Jail Board has mentioned therein that In the jail, the petitioner has been engaged as a barber. And he has converted a barren land to a fruitful garden inside the jail. And he participated in the vocational training program on plumbing and mobile repairing. And he has solved the minor repairing work inside the prison, which has been appreciated by the visiting members. Stop. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, absence of any criminal antecedent, his jail conduct, and absence of any chance of early hearing, and keeping in view the ratio laid down 30 days. The petitioner is released on interim bail for a period of 3 months. While on interim bail, he shall not indulge in any criminal activities. And violation of any terms and conditions are also. Yes, next.
17.
I will surrender certificate. And that certificate will be obtained by the land council. Yes, next. Okay.
It's moved to custody for about 11 years. He was on bail being trial by the Honorable Court. Custody certificate was called for. Yes. Custody certificate and say. This rest of circumstantial evidence.
Just a minute. Pokso Act ଅଛି।
Pokso Act and
କଣ ହେଲା notice କଣ ହେଲା?
Item 18.
May I please the elected my lord, the president appeal
I was released on an interim order for a period of 3 months, and accordingly I surrender in kind. It's the case of Milord 302. Though, and at this juncture, may I pray my Lord directed to the State Council will produce the seal conduct and the custody certificate of the petitioner. You got it? And ask him. So surrender certificate of the date.
What about its conduct while on interim bail?
That has to obtain.
Put up this matter on 10th of November 2025. The Land Council for the state shall obtain the instruction as per the order dated 23/9/2025. The Land Council for the petitioner and state shall obtain the instruction relating to the conduct of the petitioner while on interim bail as per the order dated 15/7/2022.
Item 21.
My pleasure. The applicant is custody my lord since 28/10/2014 my lord. Applicant is convicted for life my lord. Concentration 376
Yes,
Para 5 of the trial court judgment में कल का सबसे barbaric act.
trial court judgment.
Yes. Page 4. The gang rape.
Victim की (23) Mr. Jafrullah. There are 4 criminal appeals.
Pilot. I'm in criminal appeal number 1168.
Criminal appeal number 302 case.
Pilot.
How many accused are there?
Yes, previously
12
twice.
12 accused person.
12
accused person.
No, 13 persons.
13. One acquitted. One acquitted, 12 convicted. That your lordship will get page 60 accused detail.
Out of the 12, these are only 4. So that means some of the appeals there are more than one appellant.
In the criminal appeal 1 of 20, there are 4 appellants. I am for appellant number 4. And my interim application, your lordship had granted the state as well as the informant to take instruction.
Now, I'm appearing for appellant number 1. So for appeal number 3 is concerned, I have now I filed IA for bail for one appellant. Appeal number
ହଉ କଣ ହେଲା ଘଟଣାକୁ ଆସନ୍ତୁ କଣ
So Lordship ने कहेंगे order dated 1/8/2023. 1/8/2023.
The bill reject ହେଇଛି
Yes. Thereafter also.
ତାପରେ ପୁଣି ଇଏ କରୁଛି
23/4/24.
ହଁ ଦିଥର ତ ମେରିଟ ରିଜେକ୍ଟ ହେଇଗଲା ଆଉ ଇଣ୍ଟରିମ୍ ବିଲ୍ ମନା ହେଇଛି
ହଁ
ଗ୍ରାଣ୍ଡଫାଦରଙ୍କର
by then
20/11/24.
it was over, the period over, so it was not necessary to be released. The obsequious period was over by the time it was taken up. So
ତ କେତେ ବର୍ଷ ରହିଲେଣି
8 ବର୍ଷ 4 ମାସ
ଦିଥର ରିଜେକ୍ଟ ହେଇଛି ମେରିଟ
ଥରେ ରିଜେକ୍ଟ ହେଇଛି in my case and
34 injury will also have a glance to the I am appealing for information will also have a glance to the
ଆମେ ତ କହୁଛୁ ରିଜେକ୍ଟ ହେଇଛି ବୋଲି ଆପଣ ଆଉ କିଛି ଚଢିକି କହିଲେ କଣ ଆଉ ଦେବେ ସେଇଟା ତ ରିଜେକ୍ଟ ହେଇଛି ପଚାରୁଛୁ ସେଇଆ ପରା ଯେ ଆପଣ ଆମେ ଦବା ପାଇଁ କହୁଥିଲେ ହଁ ଆପଣ କଣ ତାହେଲେ ଆମେ ତ କୋଉଠି
reject ହେଇଛି ଖାଲି your lordship was called for criminal antecedent, that is why your lordship was
except that you have remained for some more period how କଣ ହେଇପାରେ
that is your lordship was pleased to call for a criminal antecedent of all the appellants
and their behavior
and also their behavior inside the custody, inside the jail.
But since there are 12 appellants, 12 accused persons, there are many appellants. It's better that all the appeals should be heard and finished up. Instead of wasting time and every lawyer will keep on hearing, it will consume more time.
In my case, mother's
yes sir,
surgery is
depending about
required.
the earlier order.
eyewitnesses are there
injury is illegal. Injury is PW
Their dying declaration is there.
PW 7 is the injured will.
7 and 2 dying.
Injury is illegal
Are there
and one joint person
ଜାନୁଆରୀ ରଖିଦବା ଜାନୁଆରୀ 2026 ସବୁ ଗୁଡାକ
Well, my bail was rejected, but here the case is mother's operation. The lordship directed them to take instruction whether the actually the certificates were correct or
You
not.
asked for interim.
Yes, ma'am.
which one
My lord, in criminal appeal 1 of 2023, my lord, there are 4 accused persons. I am for the appellant number 4 only. My friend Mr. Dafrullah is for 1, 2, and 3.
Interim application.
Their interim application, your lordship may kindly see the order dated 1/9/2020
mother settlement
and 19/9/25.
ଆଣିଛନ୍ତି କଣ
Yes, report is there.
IA number 1137
Yes, no.
Other 2 sons are there. All are able to look after the mother of the appellant.
Dion. IA number 1137 of 2025. This is an application for bail on the ground of element of the mother of the petitioner. Land counsel for the state was asked to obtain instruction on the interim application. Today, the land counsel for the state has produced written instruction received from IIC Town Police Station, Baleswar. It shows that the petitioner's mother suffering from gallbladder infection and was advised to take medicine on regular basis and be cured with the medicine is taken regularly. And there are 2 adult sons and all are able to look after the mother of the appellant. In view of such report, we are not inclined to release the petitioner on bail stands rejected. Yes, but the January of opinion.
Instead of January, it may be taken up in February or March for hearing.
February 2026. Yes, next.
Item 24.
For last year was
This case my last I don't call for the instruction in respect of its conduct while on interim bail.
କେବେ ଯାଇଥିଲା interim bail ରେ?
3/9/2024 4 ସପ୍ତାହ ପାଇଁ ଯାଇଥିଲା।
କଣ ଆସିଲା କିଛି?
এটা ইন্টারিম বেল এটা
ହଁ ସେ interim bail ର conduct
এটা প্রিভিয়াস এটা
ନା 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 interim bail ର
ସେଇଟା ଆସିନି এটা ପୁଲଟା ଦେଇଦେଇଛି
interim bail ରେ ଯାଇଥିଲେ ପରା ତା conduct ଟା ମଗେଇଥିଲୁ
ଆଜ୍ଞା ଆଜ୍ଞା ସେଇଟା ଆସିନି
ଆସିନି ଲେଖିଛନ୍ତି
ଆଜ୍ଞା
23/9/25 ରେ ଅର୍ଡର ହେଲା ନା
ଆଜ୍ଞା ଆଜ୍ଞା
କୋଉ ଥାନା ସେ ସୋରଡା ଥାନା
ସୋରଡା
କାଇଁ ରେସ୍ପନ୍ସ କରୁନୁ କଣ
ନେକ୍ସଟ ୱିକ୍ ଶୁକ୍ରବାର
Oh, 31st को रखूंगी Land Council for the state seeks some more time to produce the report regarding the conduct of the petitioner while on interim bail to the concerned IAC. IAC Soda Police Station. Put up this matter on 31st of October 2025.
Item number 26.
May I please? The report has come at
in direct contact with the victims.
In 27.
The order dated 17/10/2005, my lord, directed to append the conduct of appellant number 2. On that date, the conduct of appellant number 1 was filed. Inadvertently, I was not on the conduct of appellant number 2. Giri Govardhan Guru.
So when they were granted interim bail.
Interim bail was granted.
7/10/2024 and 21 to 2025 surrender.
17/24 रे दुई जन जाको appellant को bail दिया इतला interim bail
Minor.
for a period of 3 months.
Yes.
And after availing the same, they surrender at right time.
Minor.
Okay, अच्छा custody थिला कितने
12 years. More than
आर थिला 11 वर्ष से तो 2 रो थिला 10 वर्ष
11 years, 9 years.
It will 12, 13 are injured witness.
Huh?
It will 12 and 13 are injured.
No, that's all right. But about that conduct, we have granted him interim bail, and there is no violation of conduct, and he was 11 years by that time. Number one, number two is more than 10 years.
My lord, date of occurrence 23/9/2013. There is no direct error. 11 years, 9 months. 12 years, 1 month.
So now actually what period he has remained?
Was the total period of custody?
12 years, 1 month.
किकू basis रे आपण कहउछन
23/9/2013. 3 months.
ऑर्डर रे लिखा है कि 10 वर्ष आपण 12 वर्ष को बेसिस रे
Custody certificate Dhruva Guru that was issued on
एड़ा सब 2024 ना जेतो बेल दिया ही तला हमें कंसीडर करथु
3 months.
ओ मतलब आपण 5 मास देइथु
Dhruva Guru setala
10 वर्ष आपण कहउछन 12 वर्ष बेली सेइत पई you obtain that fresh custody certificate हला on what basis he is saying that it is 12 years. Lekhon, the Learning Council for the state has produced the written instruction received from IIC Saspan police station to show that the Ira Giri Govardhan ki appellant number 2. That the appellant number 2 has not utilized the liberty during the interim bail period. The document is taken on record. The Learning Council for the state submits that he may be given some time to obtain the custody certificates of both the appellants. Yes.
Item 28.
Get the petition as filed on IA for the interim bail matter on the ground of father's illness. He is in custody.
Item number
28, man.
28, it is for bail, not interim bail.
Bail, man.
See what I got? 2650 of 25.
Yes, man.
It's for,
On the father
on the ground of father's settlement.
Yes, ma'am. In custody, my lord, 6 or 6 months. That's 8/4/2019.
Have you obtained that instruction?
No, my lord,
Is it coming for the first time?
yes, my lord.
अच्छा ठीक है देखो IN number 2650 of 2025. This is an application for interim bail on the ground of ailment of the father of the petitioner. You have not annexed any medical documents.
I will annex, my lord.
I will ମାନେ କଣ? ଆପଣ ବାପା ବାହାରେ ରହୁଛନ୍ତି ତାଙ୍କ ଦେହ ଖରାପ ବୋଲି ଲେଖିଛନ୍ତି ଟ୍ରିଟମେଣ୍ଟ ହଉଛନ୍ତି କିଛି ଡକୁମେଣ୍ଟ ହିଁ ନାହିଁ. However, the no document, medical document has been annexed in support of the averments taken in the interim applications. Land counsel for the petitioner seeks some time to obtain instruction regarding the availability of the medical documents and to file the same put of this matter when we will commencing from 17th of November 2025.
Item 29.
Yes, Mr. Fanda. Appellant number 1.
The other appellants have also filed.
My lord, in this case, my lord directed me to call for the conduct of the appellant while on the interim bail. Criminal and
There are how many appellants?
Three appellant.
Three appellants. Okay. Jittu Biswajit Das, Chokku Niranjan, Chittaranjan Padi, Rudra. 823 which appellant number 1 time. 114925, it's appellant number 2 and 3. You have filed all the
I have filed for one, my learned friend for Mr.
They were granted interim bail.
Yes.
All of them.
Yes.
By which order?
That your lordship may kindly look. First order is
16/5/2024.
First order is 16/5/2020.
It is all written on the order dated 3/9/25.
Next order is 21/8.
Everything is written there.
My lord directed to obtain the custody certificate, conduct of appellant during interim bail, as well as the criminal antecedent. My lord, I have obtained, my lord. It is a case of triple murder. The appellant number 1, his custody for 3 years 9 months. Appellant number 2, 4 years 2 months. Appellant number 3, 4 years 2 months, my lord. So far criminal antecedent is concerned, appellant number 1 has one criminal antecedent under section 394, 364, 34 IPC. Case number hochi Khandagiri PS case number 276 dated 11/9/1995. The IO also requested to take some more time to furnish the criminal antecedent of other accused person.
Why they were granted that bail for in 1 month on time?
No, 1 month no.
How?
Initially bail was granted for 3 months. Order dated 8/6. Your lordship will
Thereafter 12 weeks.
12 weeks.
Extended 12 weeks.
Granted on 21/8/2024.
What was the ground?
Ground कौन थिला? माने period
Any medical ground or any?
माने period तो थिला 3 वर्ष.
Ground sir, was filed. Look at paragraph 3 of that order.
Which order?
That order dated 21/8. Paragraph 3 and
21/8 of
2024.
Order number 10. Order number 10.
Yes.
The lordship kindly see para 3 of the order.
Yeah. Eyewitnesses found hostile.
No, my lord, not hostile.
Yes.
No, that is the submission.
That is the submission, but now the paperwork already prepared, my lord.
One counsel for the state opposed the move and often it's a case of life of 3 young persons has taken out by the incident. Evidence appellants having rivalry, these people want to even support that the prosecution where the circumstances of the taking to assign one bench confirmation. And this were not being inclined to grant us also meritorious bail reject, but interim bail grant 12 weeks.
So far as appellant 1 is concerned, it has been extended for another 1 month. Besides that, the appellant was also granted parole by the government below for 12
So how many, who is having the criminal antecedent?
Appellant number 1. Appellant number 1 first kidnapped the deceased, one of the deceased.
Okay.
In that respect, one FIR was registered in the year 95. 11.
What is the status of that case?
I will open status.
This case, yes, 394, 364 by 34. This is relating to Jittu alias Vishwajit Das is appellant number 1.
One. Another accused is there, but he is not appellant here.
No, we are asking about the Jittu. This Jittu. The Learning Council for the state has produced the custody certificate of all the 3 appellants. And also the written instruction received from IIC Khandagiri Police Station, Bhubaneswar UPD, to show that the appellant number 1, Jittu alias Vishwajit Das, is having a criminal antecedent in which he has been charge sheeted under section 394, 364 by 34 of the Indian Penal Code. When we asked the Learning Council about the status of the case, since the case is of the year 1995, the Learning Council for the state and also you also obtain instruction, Mr. Panda submits that the matter may be taken up 10th ରଖି ଦଉଛୁ
ଆଉ ଟିକେ ଦେବି ପୁରୁଣା ରେକର୍ଡ ତ ମିଳିବ
ନାଇଁ ସେଇଟା ପଚାରିଲେ କହିଦେବନି କି ଖଲାସ ହେଇଛି କି ରହିଛି ଆଟଲିଷ୍ଟ ସେତିକି ଇନଫର୍ମେସନ ତ ପାଇଯିବ ନା ଅଲରାଇଟ୍ 17th of November 2025 এটা ହଉଛି ଖଣ୍ଡଗିରି PS କେସ୍ so 17th of November 2025. You mean to say that it has been a wrong submission has been?
No. What I am explaining, Lord. There were 3 eyewitnesses. Out of these 3 eyewitnesses, the first eyewitness is PW6, Kamal Freeman.
Yeah.
He has turned hostile.
Yeah.
The next eyewitness, Milords, is PW20, Milords. PW20 turned hostile. The next eyewitness is PW21, Nityananda Nayak. His evidence was expunged because he did not turn up for cross-examination. Now, so far as PW6 is concerned, PW6 has testified in favor of the prosecution when he was initially examined. But it appears one of these appellants has not cross-examined him at that. So a petition under 311 was filed. He was recalled, Milords. And when he was recalled, he has not resigned from his earlier
resigned from his
earlier evidence. This is what other.
So therefore it was said.
Yes. All right.
That's right.
Sure.